first Cotney Summit. It's a webinar series. Today we are focused on dealing with the issues relating to coronavirus. And I've always kind of viewed our role in the industry as a little bit different than other lawyers. I was sitting in this office on Monday, and we were fielding calls and concerns from contractors and trades across the U.S. And I was talking to John, who you'll hear from later. And I told him, we got to get the word out. We have to figure out some way to answer people's questions. It's our job to fight for the industry. And I think we're a little bit different than other lawyers because of our industry positions, both general counsel and political. So we put this together in 4 days, and I'm pleased to announce, Anita, how many attendees do we have? How many registrants? We have 602, and the registrants are adding on as I see it go up and up. So I'm very pleased with the turnout. What I'm going to do today is we've got a set presentation. I'm going to go through all the legal, and then John Kenney, our CEO and technical director, is going to talk about some of the business aspects of it. But I'm here to answer everybody's questions. So I will stay on this webinar until I have answered every single one of your questions. I don't care if I got to be here all night. My goal is to make sure that I am helping you guys through this tough time. So that's kind of the idea behind this. This is why we ended up going this route. And if you do have questions, if you hit the orange arrow and type in the question, that will get it to Anita, who will then take it forward. So let me introduce the cast of characters here. First off, let me tell you a little bit about us. We are a full service construction law firm. As we have people coming on, I'll spend a little bit of time just talking about us a little bit. We've been recognized across the U.S. for our service to the industry. We've been named OSHA Defense Law Firm of the Year for the past 4 years for the U.S. We have been named Construction Law Firm of the Year for the U.S. We've won many service awards, and we're very proud of that. I've got a great team. Let me talk about the people that are making this possible today. I am one of many. So in this training room today, obviously we're practicing social distancing in here. If you saw the images I posted on social media, we have Zane Bellamy, who is our IT director. He is assisting and making sure this thing stays on and I can continue to communicate with you. I thank him for being here. We have Anita Lum, who I cannot do what I do without her. She is absolutely 100% critical to our firm. She is the head of our marketing department. She's going to be fielding questions. She is here. As far as speakers, again, my name is Trent Cotney. This is my 21st year of practice. I have done nothing but construction law from the time I have gotten out of law school. I serve as general counsel to the National Roofing Contractors Association, to FRSA, to Western States Roofing, the Roofing Technology Think Tank, and the National Slate Association, as well as several other local associations. I am licensed in 7 states and I have 1 pending. And I will be sort of the MC for today's presentations. Ben Briggs is a partner in our law firm. He is the head of the employment department. He is licensed in Florida, Georgia, and Michigan. He handles all of our employment and HR related issues. We have received a ton of them. We are literally working around the clock to try to get everybody's questions answered. He has been recognized in both Florida Trend Legal Elite and Florida Super Lawyers. Ben and I have the privilege to say that we have the highest rated seminar at IRE with a 5 out of 5, which is something that I'm very proud of personally. Next speaker we have is Roscoe Green. Roscoe is a partner at our law firm. He is licensed in Florida and Georgia. He focuses on construction law. Roscoe is the real deal. He was a general contractor prior to being a lawyer. He is a certified general contractor in the state of Florida. He is general counsel for the minority contractors, and he's going to tell us today about all of the shelter-in-place closures. So for those of you that are from Pennsylvania, Boston, California, Miami-Dade, and now I've seen some others that have come across, he's going to update us on that. News is changing around the clock, so looking forward to hearing him talk. We have John Kenney. For those of you that know John Kenney, he is a legend in roofing. 45 years of experience in roofing. He's not a lawyer, he is the real deal. He has worked at top 100 roofing contractors. He started in New Jersey in the Northeast, and he worked as a roofer. He has gone all the way up the ranks, and his last position was Chief Operating Officer at a top 50 roofing contractor. He's going to talk to you about the business side of things. Okay, he's going to tell you how to scale down appropriately. He has been through everything. He has seen through everything. I consider him both a friend and a huge asset, and I'm looking forward to having him talk. So stay tuned for all these presentations. I think they're going to be really useful for you. We greatly appreciate our partner associations. Many of you are on here because you belong to these various associations. We serve as general counsel, provide pro bono services to associations. It's our part of giving back. So thank you for attending. We are across the United States. We have 14 offices. We are licensed in 21 states with 4 or 5 pending. Our goal is to be licensed in all 50 states. So we have the capability of answering both federal and state questions depending on where you're located. And with that, I will go ahead and get into it. What I will do is, as I finish a section, I will ask Anita what questions were asked, and then I will answer those questions, and then I will move on to the next section. First off, let's talk a little bit about coronavirus. And some of this was eye-opening for me because, like many of you, I'm a business owner. I've got mouths to feed. I've got 90 people I got to make payroll for every 2 weeks. And a lot of the questions that I had about this, I was able to answer through some research. So I want to share just a little bit of background with you. Obviously, coronavirus is interesting, and here's why it's interesting, okay? Unlike the flu, and there's been a lot of comparisons to the flu, it is an animal-based illness. And what's interesting about this is most scientists and researchers pin this back to December 19th in Wuhan province in China. And within 2 weeks, it was able to mutate and jump from animal to human. So unlike a lot of flu, which is, which you can build up antibodies for, it's a human-based virus. This is an animal-based virus, so there isn't readily available antibodies built up for it. That is what has everyone concerned, is that it is easy to mutate, not to mention that it can cause death depending on how your symptoms are. But that is the difference, and that is why some of these draconian efforts have taken place. That plus the fact that it's overburdening our healthcare system, things of that nature. Okay, what are the symptoms? 90% have fever, 70% have a dry cough, 30% have trouble breathing. It's that last line item that is the one that is the most concerning, that is causing people to use respirators and ventilators and things of that nature to make sure that they are preventing these symptoms from happening. It spreads via respiratory droplets. This is not a blood-borne disease. We're going to talk about some of the OSHA requirements. We're going to talk about, the guidelines that OSHA has put in place. This is not a blood-borne pathogen. This is spread through respiratory droplets. So coughing, sneezing, and contact, those are the things that you have to watch out for. The World Health Organization declared that this was a pandemic on March 11th, 2020. So just a few days ago, and it seems like every single day I wake up and the news is worse. The United States declared a national emergency on March 13th of 2020. And many states have taken a variety of drastic measures. I just got the notification that my son is out of school till April 15th. Okay, there's been a variety of closures of schools, closures of bars, restaurants, and clubs. For those of you that are from Florida, beaches have been closed. They've kicked the spring breakers out, which is a good thing. Cancellation of trade shows and meetings. I fly all over the place. United American made a phone call to me yesterday saying that they missed me, and I told them it was because every trade show and speaking engagement that I had has been canceled through mid-April at this point, actually mid-May. There have been a variety of shelter-in-place rules. Okay, a few days ago it was just the Bay Area. It's expanded. There's variations of it. We've seen things in Boston. I fielded 4 phone calls from roofing contractors in Pennsylvania last night after that ruling came through. Miami-Dade has had closures. Palm Beach, I just received something from their permitting department. We're going to touch on all of this. Okay. The CDC urged Americans to avoid gatherings of 50 or more, but on March 16th, President Trump recommended avoiding gatherings of 10. That's been adopted by the CDC as well. It makes life very difficult when you can't gather with 10 or more people. So what are we going to talk about today as far as the legal issues? We're going to talk about workplace mitigation and how to deal with employees. Okay, there are a variety of HR concerns. I tell you, that is the bulk of the questions that we've had coming in, is either suspension related or HR related. So Ben is going to go into detail into that. Navigating OSHA and safety for your crew. What are the OSHA requirements for keeping your employees safe, especially on a job site? We're going to talk about key contract provisions and how to utilize them. Okay, I recognize now that being able to retroactively, redo your contract is impossible. So you kind of got what you got, but we're going to talk about what you need to look at, and if you are submitting bids or you are negotiating things, stuff that you might want to include depending on what happens. Okay. And then we're going to talk about dealing with suspensions and terminations, how to properly navigate those suspensions, how to submit claims, what to watch out for. I'm going to give you real world advice as well as legal. Let's talk a little bit about workplace mitigation. Okay, obviously you want to mandate good hand hygiene, sanitizer, and wipes. One of the things that you'll hear over and over in this seminar is training. Okay, you need to have not only toolbox talks to discuss safety issues, but have your HR remind people about how to wash your hands. It sounds stupid, but sing happy birthday. There's all those techniques that you have to do in order to make sure you're cleaning your hands right. Sanitizer, we have, I don't know how many bottles of sanitizer we have here, but they're all over the place. You need to do the same thing. Mandate respiratory etiquette. What is that? Okay, that means if you're going to sneeze, you sneeze into your elbow, your shoulder, you make sure that you're not spreading that kind of stuff around the office or out on the job site. This is the most important. Clean the common surfaces, okay? Kitchens, door handles, shared space, okay? We've told our cleaning crew to make sure you wipe down everything, especially in common areas. We do the same thing throughout the day. Sick employees, absolutely stay home, okay? And they need to provide notice if they are sick so that you know what you have to do internally to continue to deal with it. Employees that exhibit signs of the virus should be sent home immediately, okay? Ben is going to talk a little bit more about how to navigate this. And obviously you want to encourage calls to healthcare providers for anybody that's sick. One of the most important things that we're learning now is, and I'm a big believer in being proactive, not reactive, okay? Creating a crisis management team to deal with this, if you don't have it already, is a must. You have to identify your key employees and who can provide support during a pandemic, okay? You may be in a state right now where it is business as usual. By Monday, you may be shelter in place. So you need to prepare for this now. Develop a remote system for work, okay? Well, John's going to talk a little bit about technology and how to use it, but if you don't have the technology in place, you need to figure out how do you communicate with your key people, okay? Determine who's second in command in all posts. If your CFO, your COO, your HR director, your safety director gets sick, who picks up the slack? Okay, who's your number two? How do you keep operating? And I've got my business owner hat on now. My job is to keep the lights on, okay? I have been through 9/11, I've been through the downturn 08, 09. My job is to keep this business going and keep food on my employees' tables. So I need to understand and be prepared in the event of anything. That's how you need to approach this. Develop HR policies that address workplace issues, okay? Ben's going to go into detail about the kind of HR policies that you need. This is not just relying on what you have in your employee manual now. This is creating specific policies and procedures to deal with the spread of COVID-19 and how to prevent it. Determine what happens if you can't access your office. Okay, with Miami shutting down earlier, I don't know how long Tampa is going to be open. And one of the things we're talking about is what happens if it's shelter in place here. How do I continue to run this office? What do we do? How do we continue to make sure that we're answering phones and dealing with issues that come up? You need to do the same thing. How do you mobilize your crew? How do you get your service people out? How do you communicate? How do you keep those dollars coming in the door? This is very important. Contact your suppliers. Contact your suppliers. Okay, it doesn't matter whether you use a traditional supplier or you have a direct purchase through a manufacturer. You need to talk to them about how you can continue to perform work. What do terms look like? Can you purchase excess material and store it at their facilities? How does that look? Okay. We're going to talk a little bit later about material shortages and how to deal with it. But one of the things we started to see is any products coming from China, there's either a delay or an increase on. So if you're buying nails from China or other products from China, you can expect a delay. Obviously, toolbox talks, okay? From a crisis management standpoint, the best way to educate your employees is to have toolbox talks. We'll talk about doing that remotely. You know, the day of being able to have your people surround a truck and you guys talk to them, that's over right now. So all HR safety issues, you want to make sure that you have your SOPs, your standard operating procedures in place, educate so that your employees know what you're doing. I'm going to talk about insurance, and then after insurance, I will ask if we have any questions, and then I will move on, and I will let Ben take over here shortly. Okay, insurance, health insurance. Okay, health insurance should cover issues with COVID-19. Should. Okay, I haven't had any issues where contractors or trades have called me about issues with health insurance, but you want to think about it. Okay, I can tell you getting access to doctors has become difficult. You know. My son's got an earache. I've got to worry about him getting to the doctor, and it's you know, you got to worry about, okay, are there sick people there? What is the protocol? Can they even see me? You know, is it backed up? What is the issue? So be prepared for waits. Have your employees and have that information available. So this is where HR really needs to step up and communicate what the plans are, what the providers are, get the contact information, make sure that they are performing their function as HR leader so that everyone knows who's on first. This question I started receiving 3 weeks ago. Okay, business interruption insurance. Does business interruption insurance cover coronavirus? Well, my job is to give you a non-lawyer answer, but I'm going to have to give you one on this one, maybe. But probably not, because many of the business interruption policies that are out there have pandemic exclusions. Or communicable disease exclusions. So after this call, after this webinar, the first thing you need to do is get on the horn with your insurance agent, talk to them in detail about what kind of coverages you have. I've asked, and in working with other contractors, I said, look, check your umbrella policy, check your personal liability policies, check everything. There may be an additional rider on there. We checked our cyber policy, and sure enough, there's a weird rider on there that gives us some business interruption coverage. Don't plan on using it, but it's nice to know that we've got it. So check all your policies. Get with your agent to determine whether or not you have coverage, because you may need to use it. Okay, this is a big one. Workers' comp insurance. Does workers' comp cover COVID-19 illness? Again, not trying to give you a lawyer answer, but the answer is maybe. Okay, here is what needs to happen for workers' comp to cover. First thing is that you have to show that it is a proven illness that is attributable to exposure on a job site. Okay, that is difficult. That is very difficult to do. The second thing that you need to be able to do is show that it is covered within your workers' comp policies. Workers' comp policies are dictated both by state, so it varies from state to state, and from your insurer. So you need to determine whether or not there is an exclusion for pandemics or diseases. And then the third thing that you need to look for is state statutes, okay? For those of you that are from the great state of South Carolina, there is a pandemic exclusion for workers' comp contained within the statute, okay? So you need to check all those three things to determine whether or not workers' comp covers it. Finally, you want to check and see what disability or life insurance is out there. Make sure your employees are notified about that. You need to know it for yourself personally, but your employees should also know that. So I'm going to take a little bit of a breather. I'm going to ask Anita if we have any questions, and then after that, we will turn to Ben Briggs.
Yes, we have one question from Todd in Florida. Is roofing an essential business under shelter-in-place law?
Okay, so the question from Todd in Florida is roofing an essential business for shelter in place in Florida? The answer to that question is maybe. Roscoe is going to talk in detail about shelter in place and what that means. The reason I say maybe is every single jurisdiction is coming out with different rules as to what is included and what is not included. So I'll give you an example. Okay, out in the Bay Area, I had a lot of contractors start calling me as soon as the shutdown went down. There are certain types of roofing that you can continue to do. So if it has anything to do with, an emergency type system to keep businesses that are considered essential up, things of that nature, you can do it. We had one roofing contractor that had his crew keep getting pulled over. So we had to create a notice for them that said basically this was an essential business and stop bothering me and let me do what I got to do. Other states have exempted it altogether and said, okay, construction is exempted. Boston had a shutdown. So one of the issues that we've seen, and I'll get into this a little bit more as we start continuing, but one of the big issues that we've seen is permitting offices shutting down. If you're in a state that has permits and you can't get a permit, what do? And I'm going to talk about that when I get to the construction portion. So Todd, stay tuned. Roscoe is going to talk to you a little bit more detail about that. What else do we have? Need anything else?
We have a question from Todd in Massachusetts.
Yep.
Do you recommend using DocuSign for toolbox talks so you have a signature that they receive the toolbox notes?
So Todd from Massachusetts, great question. You asked whether or not you should use DocuSign for toolbox talks. We're going to talk about creating a virtual office, and John is going to discuss that in detail, and I will get into it a little bit as well. But absolutely, the key with toolbox talks is they don't count unless you have sign-off sheets. And I'm being facetious, but from OSHA standpoint, you have to be able to prove that people heard you speak. So you need those sign-off sheets. So just like I'm communicating with, how many hundreds of people we have on the line now, you can do the same exact thing. If we can slap this thing together in 4 days, then I'm sure you guys can figure out how to communicate remotely with your employees, even if you don't have anything set up right now. Many of you, and I've seen the list of people that are attending, you already have advanced technology that allows you to do it. But there's a ton of programs out there that allow you to be able to communicate, obtain those signatures, obtain those sign-offs. Even an email confirmation that they received and reviewed it is great for putting it in the file. So great question, Todd. Thank you. Anything else, Anita?
We have Josh in Pennsylvania.
Okay.
He has an office in Pennsylvania, and the sister company works in Maryland. Which state laws would apply more to his company and employees?
Okay, so Josh in Pennsylvania has an office in Pennsylvania and an office in Maryland, and the question is which laws apply? Without boring you with a bunch of case law and stuff that's not going to be useful, the answer is wherever you're doing work or wherever your employees are located is the state law that applies. So if Pennsylvania has a shutdown, it doesn't mean your Maryland office is shut down, okay? And keep in mind, guys, if you did everything I told you to do, you'd be out of business. So business comes first, and we'll talk a little bit more about that when we talk about shutdowns. But generally, to answer your question, with regard to everything that we're talking about today, with the exception of federal OSHA and some contract law, it is all based on the state where your employees are actually domiciled and working. Anything else, Anita? All right, so now we're going to move on to the good stuff. This is what you guys have been waiting for. We've got Ben Briggs, who's going to come up. Ben has been a trooper through all of this. He's been right there with me working nonstop. He is going to talk to you about employment-related issues. I know many of you have questions on this, so I will get out of my chair and turn it over to Ben Briggs.
Good morning, everyone. As Trent alluded to, there are a lot of employment issues that are being brought up or brought to the surface here with the COVID-19 outbreak. There are some brand new laws. We're going to talk about laws that were just passed less than 48 hours ago. There are also a number of existing laws that have been on the books for decades that are particularly implicated by this particular pandemic. We're going to start off by talking about PTO, which is paid time off. And this is one of the issues that the brand new law that came up 48 hours ago or less than 48 hours ago changes the analysis of. But there's also a number of pre-existing PTO policies or pre-existing PTO laws that also are still in play and still have to be considered when we're analyzing this issue. So if you're going to have employees who are taking time off, and I'm not talking about employees who are working remotely from home, but actually taking time off, whether it's by their choice or by your directive, the question becomes, does that time off have to be paid time off? And generally, this is determined by whatever policy your company has in place with your employees. Whether or not they have paid time off, whether it's sick leave, vacation leave, Maybe it's all in one pot. Whether they have PTO or not, the conditions of PTO, what requirements have to be met in order for them to utilize their PTO, that is generally determined by whatever policy and agreement your company has with your employees. I say generally because the Sick Paid Leave Act, which was passed by President Trump late Wednesday evening, changes that analysis within the specific context of an individual who is taking leave for a pandemic-related reason. But if somebody's taking leave for a reason that is not covered by the Sick Paid Leave Act, then it's outside of the Sick Paid Leave Act, and we're back to our general proposition that whether or not they're entitled to have paid leave during this time depends on whatever your agreement is, whatever agreement you have in place, whatever policy you have in place. So for instance, if you just decide to shut down your office for 2 weeks, and it's not related to, the individual himself or herself is not asking for leave because of a, COVID-19 related reason, you've decided to just take the crews off the road for a few weeks to shut down the office, that would be something that we would argue is outside the Sick Paid Leave Act itself, and you would be relying on whatever your policies are with regard to PTO that you have in place with your employees. And again, in a few minutes, I'll get into the Sick Paid Leave Act itself, and that will probably kind of enlighten the distinction between your typical PTO policies and what that act now requires for employers. But in addition to PTO, which is paid time off, employees can also have time off for family leave under the Family Medical Leave Act. And the Family Medical Leave Act is another law that has been changed, or another, family leave is something that new act that President Trump passed Wednesday evening also changes. So I'm going to talk first about what the Family Medical Leave Act as it exists currently and has existed for about 3 decades now. Talk about what the Family Medical Leave Act itself requires, because it's still in place, it still exists. And then in a little while after that, we will talk about what the new Family Leave Act, the Emergency Family Leave Act, does and how that changes the FMLA. But again, the Family Medical Leave Act, FMLA, it entitles eligible employees who work for a covered employer to take unpaid job protected leave for specific reasons, specific family or medical reasons. And I'll unpack all of that. But again, what the Family Medical Leave Act does is it entitles eligible employees who work for a covered employer to have unpaid job protected leave for specified family and medical reasons. As I noted earlier, this law, the Family Medical Leave Act, is still in effect during this pandemic. So if you have someone who's currently out on family leave, or if you have someone who requests family leave for a qualifying reason under the FMLA, you have to be mindful of this law. It's still in effect. It still dictates what you have to do and how you have to handle family leave requests. Also, to the extent you have an employee or maybe a family member of an employee who contracts the coronavirus and is unable to work, that may constitute a qualifying condition under the Family Medical Leave Act. So it's important for us to talk about the Family Medical Leave Act and keep in mind, even though this Emergency Family Leave Act was just passed, the current or prior Family Medical Leave Act is still in place and is still important for us to consider whenever we're dealing with a request for leave. So we talked about, or I mentioned earlier that, in order for the Family Medical Leave Act to apply, the employee has to be an eligible employee and they must work for a covered employer. So obviously the question becomes, who are the eligible employees under the FMLA and what are the covered employers under the FMLA? So an employer is considered a covered employer under the FMLA if the employer has at least 50 or more employees going back at least 20 work weeks during the prior year, and they have at least 50 or more employees during that 20-week period within a 75-mile radius of where the employee in question works. So to kind of back up a second, if you have an employee who is asking for leave under the Family Medical Leave Act, you look at where is that employee's work site, what job site, what office are they assigned to, and then if you have 50 or more employees within 75 miles of where this employee who's requesting leave, where they work, then you are a covered employer under the Family Medical Leave Act. Now, for the employee himself or herself to actually be an eligible employee under the Family Medical Leave Act, the employee must have worked with you for at least 12 months and must have worked at least 1,250 hours during the most recent 12-month period. So if you have someone who just came aboard 3 months ago, 6 months ago, that individual is not an eligible employee under the Family Medical Leave Act. Now, again, the Emergency Family Medical Leave Act carves out an exception to a lot of these rules, and the exception, which we'll discuss in detail in a moment, applies specifically to employees who are asking for leave in order to stay home to care for children whose schools or daycare has been canceled. So again, it's a very specific area that the Emergency Family Medical Leave Act covers, and that changes a lot of what we're discussing now. But again, the original Family Medical Leave Act remains in place, and that requires for any leave request other than, to take care of a child who has to stay home because school's been closed or daycare's been closed. Absent that specific situation, any Family Leave Act falls under the normal Family Medical Leave Act. And in doing so, you have to look at, are you a covered employer? Do you have 50 or more employees within 75 miles of where this employee works? And is this employee in question actually an eligible employee? Has he or she been working for you for at least 12 months? Has he or she worked at least 1,250 hours during that 12-month period? And if the employee in question is an eligible employee, if you are a covered employer, then obviously we have to ask, what does the FMLA require with regard to this request for family leave? It requires that you provide up to 12 weeks of unpaid job protected leave along with continuing health insurance coverage if there is a qualifying reason. Now, the FMLA sets forth a handful of specific reasons one being the birth of a son or daughter, or the placement of a son or daughter with the employee for adoption or foster care. So if you have an employee, whether it's a male or female, who has had a child born, that's a qualifying reason. If they have had a child placed with them through the foster care system or through adoption, that's a qualifying reason. That's a family reason that is covered under the FMLA. Beyond that, if they need time off to care for a spouse or a child or a parent who has a serious health condition, that's a qualifying reason. Or if the employee in question has a qualifying reason themselves, has a serious health condition themselves, that's also a qualifying reason. A serious health condition is basically something where a healthcare provider finds that the employee or the employee's family member is unable to perform his or her essential job function. So if the individual employee has a condition where the healthcare provider says, because of this condition, this employee is not able to go to work, is not able to perform his or her essential job functions, that's a qualifying health condition under the FMLA. And when you look at these, when someone's asking for a leave under the FMLA, it's important to keep in mind that you have the right as an employer to require the employee to submit a certification from a healthcare provider to support their request for FMLA leave. You don't have to just blindly accept what they're telling you about their condition or about their need for leave. You can require that they provide a certificate. Now, that certificate doesn't apply in the situation where they're asking for time off with respect to a child who's been born or placed with them. You're not supposed to ask for a certificate in that instance. But when they're requesting leave in order to care for a family member who has a serious health condition, or when they're asking for leave because they themselves have a serious health condition, in those instances, you can request a certificate from a healthcare provider to corroborate the serious health condition that the employee in question is citing. Now, if an employee has a qualifying health condition and you've given them leave and they're out on leave, and at some point during that up to 12-week period, they want to return to work, or at the end of that 12-week period, they want to return to work, what are your obligations as an employer to that employee who is on FMLA leave? Well, generally speaking, your obligation under the FMLA is to give them the same job they had with the same benefits they had when they left, or an equivalent job. And an equivalent job basically means something that's virtually identical in terms of the conditions and pay or benefits of the job they had before. So it's possible that the job they had before has been eliminated or has been filled by somebody else. And in that situation, you're supposed to, if you can't give them the exact same job, give them a virtually identical, an equivalent job. Now, there's exceptions to that rule. The main one being where there is an employee in question who's out on leave is considered to be a key employee. Now, a key employee under the FMLA is one who is a salaried employee who is among the top 10% highest paid employees within that 75-mile radius we talked about earlier. So if you have a really important employee, a key employee, again, salaried, top 10% within that 75-mile radius, it may well be that you allowing that person to take 12 weeks of leave and keeping the position available is going to be a serious economic hardship to your company. You need someone in that role. It's an important role. He or she is a key employee. So in that case, you either have to hire somebody new to take that spot, and then there's no position available for that key employee any longer, or you need to, basically tell them, no, we can't give you that leave. That's the economic hardship that you're experiencing with a key employee. So if the person who's requesting leave qualifies for this key employee exception, what you're supposed to do, according to the FMLA, is notify that employee that you've basically designated him or her to be a key employee under the Act, and that if they choose to still go ahead and take the leave, you can't guarantee them a position. You'll try if you're able to when they come back, but you're under no obligation to do so. And once you provide them with that notice, that information, if they choose to go ahead and take the leave, you're not obligated to give them that 12-week job protected leave and continuing health coverage. You're basically exempted from that requirement if the person in question is a key employee. So if somebody, again, is asking for leave related, in this time related to COVID or otherwise, you can, consider that key employee exception. And again, it won't apply to everybody, obviously. It only applies to salaried employees who are within the top 10% highest paid employees within a 75-mile radius. But it is something to keep in mind when analyzing requests that come in for family leave. Now, we talked a few different times about this new law, and we're going to talk about it again in a second, but I just want to make sure it's understood that the new law only addresses a request for family leave that is based on that employee needing to take time off because that employee's son or daughter under the age of 18 is at home without adequate childcare. So the employee has to stay home because the school is shut down or the daycare is shut down due to COVID-19. So if the employee is asking for leave because the employee himself or herself is sick or needs to get medical care because of COVID-19, that doesn't fall under the new Emergency Family Leave Act. You have to now analyze that under a regular FMLA request, as well as potentially the Paid Sick Leave Act that was just passed that we'll talk about in a second. But to be clear, the Emergency Family Medical Leave Act we're going to talk about is just in addition to the original or pre-existing FMLA, and it just adds a new category specifically for employees who need time off to care for a child who can't go to school or daycare because they've been shut down for coronavirus. Now, before we turn to those brand new laws, the sick paid leave and the Emergency Family Leave Act, before we turn to those, I want to quickly touch on some wage and hour issues. So federal wage and hour law does not require an employer to pay an employee who does not work. So again, we talked about paid time off. That's separate. That's someone taking time off and getting paid for it. We've talked about FMLA leave, which is unpaid job protected leave. Wage and hour law, federal wage and hour law only requires you to compensate your employees for work they actually perform. So if you have to let people take time off, whether they've asked for it or you're forcing them to do so, and they're not actually performing any work for you, federal wage and hour law does not require you to compensate them for that. However, if you have an employee who you consider to be a salary exempt employee, meaning you're not keeping track of that employee's hours, you're not paying that employee overtime if they in fact work overtime, because that employee is considered to be salary exempt under the Fair Labor Standards Act. If you have an employee you consider to be salary exempt and you then reduce their salary or don't pay them their full predetermined salary, you risk losing that exemption. Again, it doesn't mean that you're not allowed to not pay them when they don't work. It simply means if you choose to reduce or change their salary based on them not working, you risk possibly losing that exemption, that salary basis exemption, so that now you would have to keep track of their hours worked. You would have to pay them overtime if they work overtime. Now, significantly, there is an exception to the requirement that you pay a salaried employee a consistent salary each and every work week. In order for the employee to be salary exempt under the Fair Labor Standard Act, you need to pay that employee a consistent predetermined salary every single week. An exception to that rule is when the employee in question works 0 hours in a week. If the employee works 1 hour in a week, half a day in a week, you have to pay them their full salary. Otherwise, you risk losing that exemption. But if the employee works no hours, doesn't work even a half day, doesn't work at all during a week, you don't have to pay them at all for that week, and doing so does not risk losing the salary basis exemption. So if you have, an employee or a department who you've basically given 2 weeks off, they're not going to do any work, whether remotely or otherwise, they're not going to do any work during that time, you are not obligated by federal wage and hour law to pay those employees. And even if it's a salary exempt employee, you do not have to worry about losing that exempt status for that employee if the employee doesn't work any time at all within the week. However, if they work some during the week and you just pay them a prorated salary, for example, doing so may compromise or cost you that salary exemption they would otherwise have. Now, one final note, because a lot of us are dealing with remote employees, people working from home. It's a different world we live in now than we did a week or two ago. Within that context, it's important to keep in mind that if you have employees who are performing work remotely, you need to compensate them for that time. You need to compensate them for that work. And you need to keep track of the work they're performing, the hours they're performing, in order to properly pay them. If you have a non-exempt employee, non-exempt under federal wage and hour law, you are required to keep track of all hours worked by that employee each and every workday. That requirement still exists whether they work in the office or out in the field or at their house. You have to keep track of their hours worked, and you have to pay them for the time worked, including at least minimum wage and overtime if they work it. Those laws still exist, and it can be complicated when now you're having to figure out a way to keep track of time records and to compensate employees who normally are in the office every single day but are now doing so remotely. It creates an administrative and logistical burden that it's important for you to figure out. How are we going to keep track of time? How are we going to get the employees to correctly report their time? How are we going to record it correctly? How are we going to distribute the correct compensation to those employees? And if it's a situation where that employee has not worked remotely before, or you haven't had any employees working remotely before, it may require a new policy to be put in place, a new protocol to be put in place. But doing so as fast as possible will help ensure that during this time there is no violation of wage and hour laws. And violation of wage and hour laws, if they're prosecuted, typically involve liquidated damages, double damages, attorney's fees, costs, potentially civil penalties. Wage and hour violations are not the kind of violations that any company is looking for. So again, if you have employees who are working remotely, you have to put in place policies and protocols that will help ensure that you are properly tracking their time while they're working remotely and properly compensating them for doing so. Now, getting to the brand new laws that were passed Wednesday night by President Trump. and were enacted Wednesday night by President Trump. They're all contained within the Family First Coronavirus Response Act, the FFCRA. The Family First Coronavirus Response Act includes within it several different acts. The two we're going to talk about today, the two most important new laws regarding employee leave, are the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act. Both of those were enacted Wednesday night. Both of them go into effect 15 days after their enactment on Wednesday, and they will remain in effect through December 31st. So these new laws we're about to talk about are going to go into place in less than 2 weeks, and they're going to be with us for the remainder of the year. So it's important that we understand what these laws require, how we can comply with them, and we start immediately putting into place the right policies and protocols to ensure that when this becomes effective in less than 2 weeks, your company understands what's being required of it and is able to comply with it. So the first act we're going to talk about is the Emergency Paid Sick Leave Act. And the Emergency Paid Sick Leave Act is essentially unprecedented. There is no prior federal law that requires an employer, a private employer, to provide paid sick leave. This act, the Emergency Paid Sick Leave Act, is not amending any prior law. It's not supplementing any prior law. It in of itself is a new law with really no precedent. The Emergency Paid Sick Leave Act applies to all employees of private employers with fewer than 500 employees. So if you are a company that has less than 500 employees, it applies to all of your employees, full-time employees, part-time employees, employees who have been with you for 10 years, employees who have been with you for 1 week. All of your employees are covered by the Emergency Paid Sick Leave Act as long as your company has fewer than 500 employees. If you have 500 or more employees, this law does not apply to you. But again, most companies out there are going to have to deal with this law because most companies have fewer than 500 employees. Now, there is a small business exemption that is set forth in the act that was again enacted just Wednesday night. Now, the new act states that if you have fewer than 50 employees, so if you have fewer than 50 employees, you may be eligible for a small business exemption if complying with this Emergency Paid Sick Leave Act would, and quote, jeopardize the viability of your business. So if you can show that complying with the Emergency Sick Paid Leave Act would jeopardize the viability of your business, and you have fewer than 50 employees, you may be eligible for the small business exemption. Of course, the act, which was enacted less than 48 hours ago, doesn't go into any detail beyond what I just told you about this exemption. It states that the Department of Labor is authorized to issue federal regulations regarding this exemption. Basically, they're allowing the Department of Labor to figure out what exactly constitutes a small business under this exemption and what the qualifications are for it. So the Department of Labor is authorized to figure that out for us. They haven't done so yet, obviously, and this has only been around for 48 hours. So it's important to stay tuned. If you have less than 50 employees, you want to keep track, stay tuned to what this exemption is and how you can qualify for it so that you can hopefully find a way to basically exempt your company from the Emergency Paid Sick Leave Act. Now, assuming that you have fewer than 500 employees and you have more than 50 or you don't meet the small business exemption, then this will apply to you. And if it does, it's important to understand what this brand new law requires when it goes into effect in less than 2 weeks. Under the Act, employers must provide paid sick leave to employees who cannot work or telework for COVID-19 reasons. And there are 6 specific qualifying reasons that are set forth in the Act. One is where an employee is subject to a coronavirus quarantine or isolation order. So if the employee is subject to a coronavirus quarantine or isolation order, they are entitled to paid sick leave. If the employee has been advised by a healthcare provider to self-quarantine due to coronavirus concerns, that is another reason that would qualify that employee for paid sick leave under the Act. If the employee is experiencing symptoms of coronavirus and is seeking a medical diagnosis, they are entitled to paid sick leave for the amount of time it takes them to seek that medical diagnosis. If the employee is him or herself not actually sick or having an experiencing any symptoms, but instead that employee is caring for an individual who is subject to a coronavirus quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine due to coronavirus concerns, then if the employee is caring for one of those individuals, then the employee is eligible for paid sick leave under the Act. And if the employee is caring for the employee's child whose school or childcare has closed or is unavailable due to coronavirus concerns, that is another reason that would make that employee eligible for paid sick leave. And there's the sixth reason cited by the Act is kind of a catch-all. Basically says if the employee is experiencing any conditions that are substantially similar to the ones we just talked about, as set forth by the Health and Human Services, then the employee is also eligible for paid sick leave. But again, to kind of summarize the conditions we have to look for, if you have an employee who comes to you and asks for paid or asks for leave because that employee is subject to an order requiring them to be quarantined or isolated, in that instance, they are eligible for paid sick leave. If the employee can come to you and show that they've been advised by a healthcare provider to self-quarantine due to coronavirus concerns, if they can show that a healthcare provider has advised them to do so, they're now eligible for paid sick leave. If they themselves are experiencing the symptoms and they need time off in order to get medical diagnosis, they're eligible for paid sick leave for however long it takes them to get that diagnosis. Or if instead they're caring for a child who's at home because of corona-related school closure or daycare closure, they are eligible while they're home caring for that child for paid sick leave. Or if they are staying home to care for an individual who themselves is subject to a quarantine order, or who themselves is experiencing or has been advised by a healthcare provider to be quarantined, then the employee who's caring for that individual is eligible for paid sick leave. Now, what does the eligibility for paid sick leave actually mean? Well, if it's a full-time employee, so if the employee who's requesting this leave is a full-time employee, they are entitled to 80 hours of paid sick leave. If it's a part-time employee who's making the request, the part-time employee is entitled to the average number of hours that the employee would work in a 2-week period. So if the part-time employee typically works 25 hours a week, they are now entitled to 50 hours of paid sick leave. Full-time employees get 80 hours, part-time employees get the average hours worked by the part-time employee during a 2-week period. So the maximum amount of time that you are going to be paying any employee paid sick leave under this Act will be 80 hours. You will not have to pay any single employee more than 80 hours of paid sick leave under this Act. Now, the amount of money you are paying to the employee for the paid sick leave depends on the conditions or the basis for which the employee is asking time off. So we went through 6 different categories. For some of those categories, the employee is entitled to be paid their full wages. For other categories, the employee is only entitled to be paid 2/3 of their wages. And we're going to go through that in a second here. So if an employee is taking time off for one of the 3 reasons we discussed first. So if the employee is taking time off because the employee is subject to a quarantine order, or second, if the employee has been advised by a healthcare provider to self-quarantine, or third, if the employee is experiencing symptoms of coronavirus and is seeking medical diagnosis, for any of those 3 reasons, the employee is entitled to full pay of their normal wages, capped at $511 per day. So if the employee in question makes more than $511 per day, they're doing pretty well for themselves, but also they're sick leave is capped at $511 for that day. And so for, the aggregate you would have to pay, the most you'd ever have to pay an employee under the Emergency Paid Sick Leave Act would be $5,110, which is basically that $511 maximum per day payout times 10 days, because this 80-hour of paid sick leave contemplates 10 8-hour days. So the most you're going to pay to any employee will be $5,110. And that would be if the employee takes the full 80 hours of paid sick leave and the employee makes at least $511 per day for that time, and the employee is taking sick leave for one of the first 3 reasons we discussed, where the employee is subject to a quarantine order, or a healthcare provider has advised the employee be quarantined, or the employee needs time off to get a medical diagnosis for corona symptoms. Now, for the other 3 reasons we talked about, where you're caring for a child who's at home because school's been closed or a daycare's been closed, or you're caring for an individual who has been quarantined because of corona, or if you're under that catch-all one where it's any other similar condition as put forth by the Human Health Services. If you're in one of those 3 other categories, the employee in question is only entitled to 2/3 of their pay. So whatever they would make during a normal day, they're entitled to 2/3 of that, with a cap of $200 per day. So under these latter 3 reasons, if the employee is getting leave under one of those 3 reasons, the most they're entitled to is 2/3 of their wages, capped at $200 per day, which would be a maximum of $2,000 under the Sick Paid Leave Act, which again would be the full 80 hours or 10 days at a $200 per day maximum. And one important thing to consider too, when an employee is requesting paid sick leave under this brand new act, which again goes into place in approximately 13 days, if the employee is requesting that leave, but the employee might have accrued PTO, maybe the employee has a week of paid time off that he or she has accrued, the act states that it is a violation for you to force that employee to take their PTO before using paid sick leave. So if you have a pre-existing leave policy that is separate from the Paid Sick Leave Act, that is considered distinct and separate from it. You cannot basically compromise or reduce the paid sick leave the employee receives under the act by requiring the employee to utilize any sick leave or paid time off leave that you already have in place, or any accrued PTO they have. They can basically keep storing that up, use their up to 2 weeks of paid sick leave, and after that they could potentially use their PTO, but you can't require them to use the PTO in exchange for, or in addition, or in place of this paid sick leave, or to make them use a PTO before beginning their paid sick leave. They can begin their paid sick leave right away as soon as this goes into place. They don't have to first use any accrued PTO they have. One final thing too is the act requires employers to post a notice within the workplace that will advise your employees about their rights under the Emergency Paid Sick Leave Act. Obviously, there's a number of other federal laws, the FMLA, the FLSA, that have already, OSHA, there's all these different posters we already have up in the workplace. This is a new one. The Department of Labor is required to create this new poster. To my knowledge, it has not yet been created. Once the Department of Labor creates it, you are then required, once this goes into place in about 2 weeks, you are required to have that up in a conspicuous place within your workplace for the purpose of advising your employees about their right to paid sick leave. So again, keep in mind that poster in theory will be in place by the time this goes into effect in about 13 days. And when it does, you're supposed to have that up in your workplace. The other new law that was part of the Families First Coronavirus Response Act, the other new law is the Emergency Family Medical Leave Expansion Act. While the Paid Sick Leave Act that we just discussed is a brand new law, the Emergency Family Medical Leave Expansion Act simply amends the pre-existing Family Medical Leave Act. So this is not a brand new law, but instead is an act that amends the pre-existing FMLA, which we discussed earlier. Under this new expansion, it basically amends the FMLA to add a new category of qualifying circumstances that would allow an employee to take job protected leave. As you recall, the FMLA provides that if an employee needs time off in order to care for a child that was born or adopted or placed with them, or if they need time off to care for if they need time off because of a serious health condition that they are experiencing or a serious health condition that a family member is experiencing, those are all qualifying conditions under the FMLA. There's also an additional condition under the FMLA where you're taking time off to care for a service or military member. Those are the, again, the five specific reasons that the FMLA allows an employee to take leave. This brand new law that came into place less than 48 hours ago adds a new reason. So it adds a sixth reason, if you will. And that is for when employees need time off, not because of any illness that they have or any illness that a family member has, and not because of a birth of a child or placement of a child, but instead they need time off because their child under the age of 18 is at home and needs them at home to care for that child. They need time off to care for their minor child whose school or daycare has been closed because of a COVID-19 reason. That is a limited situation that this new law puts into place. And when an employee is requesting time off for that specific reason, not for one of the other reasons that the FMLA already provided, they're not asking time off because of a serious health condition they have or a family member has. They're instead asking time off specifically because their child is stuck at home with school being closed or daycare being closed. If that is the request, there are new rules that apply specifically to that request for family leave. The new rules that apply just to that request for family leave state that if the employee has been working with you for just 30 days or only 30 days, that's all that's required, they are an eligible employee for that specific reason. So for a request for leave based on the need to care for a child at home whose school has been shut down or daycare has been shut down, if the employee asking for that leave has been working for your company for at least 30 days, they are an eligible employee under the new act. Again, if they were asking for a leave for a different reason under the original FMLA, they would have to have worked for you for 12 months in order to be eligible. Now, if it's for that one specific new reason, they only have to be an employee of your company for 30 days. Likewise, while the old FMLA has a 50 employee threshold, meaning that in order for the FMLA to apply, you have to have at least 50 employees. That's still in place. However, if the request is for this new specific reason to care for a child whose school's been closed or his daycare has been closed for COVID-19 reasons, if that's the request, there is no longer a 50 employee threshold. This means that you could have 10 employees and you don't have to comply with the FMLA as far as any other leave request other than a request for time off to care for a child whose school or daycare has been closed. If that's the request, there's now no minimum employee threshold, and the FMLA, with regard to that limited scope of that one type of request, now does apply to you. The one exception would be if you, again, are a company with 500 or more employees, then this law doesn't apply to you. So similar to the Sick Paid Leave Act, which again only applies to employers with fewer than 500 employees, the Emergency Family Medical Leave Act also only applies to employers with fewer than 500 employees. But if you have fewer than 500 employees and the employee making the request has been working for you for at least 30 days, you have to take this law into account because it does apply to that situation, as long as the request itself is for time off for your employee to care for his son or daughter who is at home because school's been closed or daycare has been closed because of coronavirus. Again, there is the same small business exemption stated in the act that we talked about under the context of the Paid Sick Leave Act. That same small business exemption also exist under this separate act. And again, it basically says that if you do have fewer than 50 employees and you can show that complying with the Emergency Family Medical Leave Expansion Act would threaten the viability of your company, you may be eligible for a small business exemption. So you want to stay tuned again, because the Department of Labor has not put out any sort of obligations, requirements. They haven't put forth what the mechanism is by which you would have to actually make an application for that exemption or to seek it. But again, if you have fewer than 50 employees, keep in mind that this small business exemption may apply to you, and you're going to want to stay tuned and to keep monitoring what that exemption looks like. But if you have more than 50 employees, but less than 500, you're squarely within the scope of this new Emergency Family Medical Leave Expansion Act. And that means that if you have an employee who's been with you for more than 30 days and they ask for time off for to care for a child whose school's been closed, daycare's been closed, they are entitled to that time off. Also, what's significant about the new act is that if that's the reason they're asking for time off, that one limited reason, they are entitled to up to 12 weeks of job protected leave, just like they would be under the normal FMLA. However, while the normal FMLA provides for 12 weeks of unpaid leave, this new act, which only applies to that one limited situation, gives the first 2 weeks of unpaid leave, but then after that, the remaining 10 weeks of leave, if the employee takes the full 12 weeks, their last 10 weeks of leave is to be paid, and it's paid at 2/3 of the employee's normal pay rate with a $200 per day cap. So at most, you would end up paying $10,000 to a single employee under the Emergency Family Medical Leave Act, because you'd be paying $200 per day for 5 days a week, which is what the act contemplates. So at most $1,000 per week to one of these employees, and at most for 10 weeks, because the first 2 weeks or the first 10 days means the same thing under the act, are unpaid. So again, if you have an employee who makes a request for time off to stay with a child who's stuck at home with all the schools that have been shut down and daycares have been shut down, and that employee has been with you for at least 30 days, unless you have more than 500 employees, you now have to, under this new law, give them 12 weeks of job protected leave with continuing health benefits. And after those first 2 weeks have expired, if they're still needing time off, whatever time off they need beyond that, up to 12 weeks, is going to be paid at 2/3 of their salary with a cap of $200 per day. And then when they want to return to work at the end of their FMLA leave, it's treated the same as it would be under normal FMLA, meaning that you're required, generally at least, you're required to give them the same position they had before or an equivalent position. This new act, though, does provide a small exception to that. So if you are an employer with fewer than 25 employees, you now can basically, if you can show that the position no longer exists due to economic conditions, then, or other changes in your business caused by the coronavirus. So if you can show that coronavirus has basically caused us to no longer have that position available to you, and you have fewer than 25 employees, you now are no longer required to hold that position for the employee. So if you have less than 25 employees and you can show that the coronavirus has caused your business to basically eliminate certain positions, including the position that the employee on leave had, then now you're no longer required to give them that job protected leave. But other than that kind of limited exception, you are required to give 12 weeks of job protected leave with continuing health coverage. And the final 10 weeks of that are to be paid at 2/3 the employee's normal rate, capped at $200 per day. So, kind of going over, the existing laws as well as some of these brand new laws, we kind of want to shift or pivot a little bit to, some of the potential HR issues that we're going to be facing, or we already are facing, frankly. So a lot of those FMLA issues have already been discussed, so I'm not going to touch on that too much now, as well as the new laws under the Family First Coronavirus Act. this, again, the HR policies we have to put in place with respect to those new laws are, HR policies that, to date haven't been necessary because those new laws did not exist until Wednesday. But when they go into effect within 13 days, it's important to, again, make sure that your staff, your HR department understands what the new law requires and complies with it. Complying with it, again, requires having that poster up in a workplace. It requires, being able to evaluate each leave request to determine whether it falls under the Emergency Family Medical Leave Act or if it falls under the Sick Paid Leave Act. And to be able to evaluate those leave requests under those two new acts, your staff has to understand, your HR department has to understand what those new acts are and what they require. Beyond complying with the FMLA and with the new leave acts, it's also important to understand what you have to do to comply with the Americans with Disabilities Act. That's the ADA. The ADA, just so you understand, kind of as a quick background, applies to all companies who have 15 or more employees. So if you have 15 or more employees, the Americans with Disabilities Act applies. And the ADA prohibits discrimination against a disabled employee or job applicant, and it requires an employer to provide a reasonable accommodation to a disabled employee or job applicant to allow that employee or applicant to perform the essential duties of his or her job. A reasonable accommodation, can be leave from work, work from home. Those are considered to be considered to be a reasonable accommodation under the ADA, which comes into play in this, in the context of this coronavirus pandemic, because you have a lot of employees who are going to be asking for leave, and you have to evaluate those not simply under the FMLA and the new leave acts we just discussed, but you also have to evaluate them within the context of the ADA to determine whether or not that leave would constitute a reasonable accommodation that the ADA requires you to provide. Significantly, no reasonable accommodation, including leave, is required if you can show that providing that accommodation would impose an undue hardship on your business operations or finances. So again, the ADA only requires a reasonable accommodation. If you can show that whatever accommodation your employee is requesting, including leave, would not be reasonable, it would instead impose an undue hardship on your business operations, you are not required by the ADA to provide that accommodation. You are not required to provide leave, for example, if you can show that doing so would impose an undue hardship on your business. And the other, and one kind of other small thing to keep in mind with the ADA is that, if you do grant leave as an accommodation under the ADA, again, which can be separate from or distinct from leave under the Family Medical Leave Act or the new paid leave acts, if you provide leave under the ADA, that leave does not have to be paid. The ADA does not require you to provide paid leave whatsoever. It simply says instead of terminating an employee, you allow them time off as a reasonable accommodation, but it's unpaid time off under the ADA. And, as we look at, COVID-19, the first question, that we typically would have is, under the ADA at least, is whether or not the virus itself or someone who contracts the virus, whether that is considered to be a qualifying disability under the ADA. Because again, the ADA requires you to not discriminate against employees or job applicants and to instead provide them reasonable accommodations where they have a qualifying disability. So whether or not coronavirus itself is a qualifying disability is a brand new question, because coronavirus until recently, frankly, did not exist in this country. And whether or not it ends up constituting a qualifying disability will probably depend on how severe the individual case of coronavirus is. If the employee simply has to miss a few days of work but then feels fine and is back to normal, which my understanding is the case for most people who contract coronavirus, in that scenario, it would not constitute a qualifying disability. However, if it became a serious condition, if it developed into something that became more serious, that was more limiting, that rendered them bedridden for an extensive period of time, in that scenario, it could become a qualifying disability under the ADA. So again, you'll want to kind of evaluate on a case-by-case basis to determine whether or not somebody who actually contracted coronavirus has indeed, a qualifying disability that requires you to now evaluate whether or not a reasonable accommodation can be provided as required under the ADA. There also is an exception worth noting where the ADA has an exception for, it basically allows employers to terminate or refuse to hire an employee who poses a direct threat. And a direct threat is under the ADA considered to be a significant risk of substantial harm to the health and safety of that employee or others. So, for example, I had it come up recently in the instance of epilepsy, someone who has epilepsy and wanted to work for one of our client companies. Well, if they're wanting to work the position of a driver, they want to be they want to be a driver for your company and they have epilepsy. While that is a qualifying disability under the ADA, it would likely, in my position, I would argue it would meet the direct threat exception because allowing them to work with that disability would pose a significant risk of substantial harm to the health and safety of your other employees or the public at large. That's also relevant to consider in the context of COVID-19, because if somebody has COVID-19, and if it does in fact qualify as a disability for that individual, well, there's a possibility that they would pose a direct threat to your company. Now, you're still required to go through the analysis of whether you could give them a reasonable accommodation, such as leave. So if just giving them leave for a few weeks would allow the symptoms to basically subside enough that they are no longer a direct threat, then the ADA would probably require you to provide that leave unless you could show that doing so would be an undue burden to your company. But if it seems clear that providing them with leave or maybe some other reasonable accommodation will not adequately address the threat that they pose, if it's something where if they test positive for that disease for a prolonged period of time, there may not be any reasonable accommodation that doesn't, there might not be any reasonable accommodation that avoids the direct threat that your workplace would experience by allowing that employee to continue working for you. And in that situation, in that case, you'd be permitted under the ADA to let that person go. And all of this kind of comes back to how do we obtain employee information, employee health information at this time. Normally under the ADA, what you can ask an employee about their medical condition or their health is very limited. But the EEOC, the Equal Employment Opportunities Commission, has provided guidance specifically for a situation like the one we have right now, where there is a pandemic. Where there is a pandemic like the COVID-19, an employer's ability to ask their employees medical questions is significantly expanded. You have a much greater flexibility on what you can ask an employee with regard to their health when there is a pandemic like there is currently. So in the case of a pandemic, the EEOC has stated that you have greater flexibility in conducting medical examinations and screening the workplace if doing so is consistent with a business necessity, or if you have a reasonable belief that the employee poses a direct threat to the health and safety of others at the workplace. So again, that ties in a bit to the direct threat exception under the ADA itself, but an example of this would be an employer may institute screenings for employees who exhibit flu-like symptoms in the workplace. But keep in mind, you cannot make you cannot inquire about an employee's flu-like symptoms if they already are working remotely and don't actually come in contact with other employees or pose a threat to the workplace. So again, the loosened prohibitions, if you will, against requesting employee medical information applies specifically to instances in which you can show that the information you're requesting is necessary for your business operations or is necessary to protect the health and safety of your workplace. So you want to make sure, even under this pandemic loosened standard, that the information you're requesting is directly related to your business needs or to your workplace safety. The EEOC under, within the context of COVID-19 or similar pandemics does permit employers to do temperature checks with a thermometer. You can make all of your employees submit to temperature checks on even a daily basis to determine whether or not they are running a temperature, have a fever, and in which case, if they do exhibit any symptoms or do have a temperature, you can send them home, and you can require them to not return to work until they've basically been symptom free. And you can again take their temperature when they return to work to make sure that they are in fact symptom free. These are examples of the screening or examination of opportunities or options available to you that are not normally available to an employer, but are available under this kind of unique circumstance that we're in. You can ask employees questions to determine whether or not they pose a risk to your workforce. You can ask them questions such as, have you or anyone in your family been in contact with a person who tested positive for COVID-19? If they have, then you can require them to go home, or you can require them to, again, submit themselves to further examination to determine whether or not they in fact have any symptoms of COVID-19. You can also ask them if anyone in their family has been in contact with a person who's simply going through the process of being tested for COVID-19. So you can ask them, maybe not somebody they've been in contact with who has a confirmed COVID-19 diagnosis, but is going through the process of making that diagnosis. You can ask them if anyone in their family has traveled outside of the country within the last 2 weeks. You can ask them, if they say yes, where did you go? You can ask those questions of them. That is, the EEOC has specifically permitted that you can ask those sorts of questions under this unique circumstance with the pandemic we're experiencing. You can ask them if they have been medically directed to self-quarantine due to possible COVID-19 exposures. You can ask them if a medical provider has required them to self-quarantine. You can ask them if they have trouble breathing, or if they have a fever, cough, shortness of breath, sore throat, runny nose, chills, really any of the symptoms of COVID-19, the flu-like symptoms. You can ask them those questions. And again, you can do so under the current circumstances, and it doesn't violate any law. You're not, again, as long as you're asking those questions reasonably related to the safety of your workplace or your business necessities, you can go ahead and do so. And if, depending on their answer, you can send them home and basically require them to pass certain, medical examinations before they come back to work. And one thing to keep in mind with obtaining this health information, so you're getting health information potentially from the medical provider. You can get health information from the tests that you actually yourselves perform at work, like taking their temperature. You're also getting medical information from asking them questions and the answers they provide. All this medical information that you are obtaining is information that you as the employer have a duty to keep confidential to the extent you can. And what that means is, you're not telling anyone who doesn't need to know what that information is, what the results were. Obviously, if your HR person is taking that information, and they can report that up the chain to a manager who makes a decision as to what to do with the employee. But it has to be on a need-to-know basis, limited to just those who have to know the information. If you have an employee who you learn is positive for COVID-19, you have a duty to tell the other employees who may have come in contact with that employee that there was an employee within the workplace who tested positive for COVID-19. That way your other employees understand their potential exposure and they can act accordingly. However, in doing so, you're not supposed to identify the individual in question. You don't say, John tested positive for COVID-19, so you better get tested too. You instead simply inform the affected employees or the potentially affected employees that someone tested positive for COVID-19. Again, just because you're allowed to take in or obtain more employee health information in this circumstance than you are normally allowed to do as an employer doesn't at all alleviate the employer's duty to keep that information confidential to the extent possible. And one final thing to touch on, to the extent that things go bad enough, go far enough that you have to contemplate mass layoffs or contemplate closing down offices or plants. The Worker Adjustment and Retaining Notification Act, the WARN Act, governs mass layoffs or plant closures, which can become an issue in a situation like this where across the country businesses are shutting down. Your customers are they're not calling anymore. They're telling you to stop coming, stop working on their house. These economic realities can often lead to mass layoffs or to plant closures. And whenever that's something that you are contemplating, hopefully you're not, and maybe you aren't today, maybe not next month, but it might get to that point. You need to keep in mind what the Worker Adjustment and Retraining Notification Act, what the WARN Act requires. The WARN Act only applies to companies that have at least 100 full-time employees who work at least 20 hours per week. So full-time means at least 20 hours per week under the WARN Act. You need to have at least 100 full-time employees for this federal law to apply to you. However, keep in mind that many states have adopted mini WARN Acts, which expands the scope of WARN to companies that may have fewer than 100 employees. So if you have fewer than 100 employees, that doesn't necessarily mean that you should just ignore whatever I'm about to say about the WARN Act, because you may indeed have a state law that requires WARN to be applied to your company, even though you have fewer than 100 employees. But if you do have over 100 employees, full-time employees, then WARN does apply to you. And if you're considering a mass layoff or a plant closure, you have to keep in mind what WARN requires. And it essentially requires that you provide at least 60 days advance notice to all of your employees that you're planning to lay off before laying them off or closing the plant. So if you have an employee who will be affected by a mass layoff or a plant closure, you must let them know at least 60 days ahead of time of what you're planning to do. And during that 60-day period, you are required to pay the employee at their normal rate with their normal benefits, and you allow them to continue working unless you have health reasons or otherwise safety reasons where you don't want to do so. But they are entitled to have 60-day notice, and during that 60-day period, they're supposed to continue receiving their normal compensation and benefits. And again, that applies if you're going to do a mass layoff or a plant closure. But the Act specifically defines what is considered to be a mass layoff or a plant closure. So not all layoffs are considered to be mass layoffs under the Act to require that 60-day notice period. When it looks at a mass layoff, when the WARN Act looks at a mass layoff or a plant closure, it looks at it in the terms of an employment loss. So an employment loss can be either termination or a layoff of more than 6 months, or a 50% or more reduction in hours for more than a 6-month period. So if you are maybe not technically terminating a bunch of people, but you're instead reducing their hours by 50% or more, that may be considered an employment loss under the Act and would count just the same as if you had actually terminated the employee. And for a mass layoff, there's basically two different situations that can apply, two different situations that can trigger the WARN Act's 60-day requirement. The first is if your company has an employment loss, again, either termination, layoff of 6 months or more, or just simply a reduction of hours of 50% or more. If you have an employment loss that affects at least 500 employees at a single job location within a 30-day period, then the WARN Act applies. So if you have at least 500 employees who are affected by this within a single job location, and again, 500 employees that are affected by it within a 30-day period, then it's considered to be a mass layoff, and all of those affected employees are entitled to that 60-day notification period. The other way in which the mass layoff may apply is, okay, you didn't lay off 500 employees, or you didn't reduce the hours of 500 employees, but you did have an employment loss of at least 50 employees at a single site within a 30-day period, and that loss of at least 50 employees constituted at least 33% of the workers at that site. That's a lot of numbers. It's a bit confusing even for me. But again, just to kind of reiterate, if you are laying off at least 50 employees within a 30-day period, or you're reducing their hours by 50% or more within a
30-day period at one location, at least 50 employees, and you have less than 150 employees at that location, you have now laid off over 50 employees, and it constitutes at least 33% of your workforce there, in which case, under WARN, that is considered to be a mass layoff. And all of those affected employees are entitled to 60-day notice, and during that 60-day period, they're entitled to be paid their regular compensation and benefits. So, and you know, one thing to keep in mind with COVID-19 though, if you have an employee who is unable to work because of COVID-19, they don't actually count as one of the employees that you are laying off. They don't have to be considered under the employment loss as far as the numbers go. And again, that's a unique situation here that might be worth keeping in mind. There's two other main exceptions to the WARN Act. So if you're worried about WARN possibly applying to your company, you have at least 100 full-time employees, you might have to lay off a bunch of people at one time, or you might have to close down a plant at one time, or you may have to reduce everybody's hours by at least 50% at a time. If you're worried about WARN applying to your company, there are two exceptions that may be relevant. The first is a natural disaster exception. WARN does not apply in the instance of a natural disaster. You don't have to give that 60-day notification period in the instance of a natural disaster. Now, this COVID-19 outbreak has not yet been declared a natural disaster by our federal government, but it's possible that it could. And if so, that would be an exception you want to keep in mind if you're contemplating a mass layoff. The other exception is the unforeseeable business circumstance exception. So the normal 60-day notification period is reduced to a shorter period of time when the plant closing or the mass layoff is caused by business circumstances that were not reasonably foreseeable. And I would argue, and I think it's a reasonable argument, that the COVID-19 outbreak and the economic effect that it has had on this country was not a reasonably foreseeable business circumstance. So I would consider, I think there's a good argument that the COVID-19 outbreak, this pandemic, was an unforeseeable business circumstance. So if you're having to lay off a mass amount of people because of this unforeseeable business circumstance, you are no longer required to give them 60 days notice with pay and full benefits before you go ahead with that mass layoff. You are still required to give them as much prior notice as you can before the mass layoff. But again, if it's not economically viable due to this unforeseeable business circumstance, it's not economically viable for you to keep them on the payroll for 2 months, then you are not required to do so under WARN. Are there any questions on, I know we went through a lot. I know I talked a lot about all these different numbers and different acts. I'm not sure if there are specific questions I can field to probably maybe help fill in the gaps or provide some more information on any of that.
So let me get on. So we've had 73 questions, man.
Oh.
So what we're gonna do, I don't want to keep you guys on here all day. So what we're gonna do is we're gonna answer 5, and then offline we will answer the rest. Okay. A couple of things our internal compliance guy reminded me. We are not giving you legal advice. This is educational information only. Please contact us directly if you want questions about your specific situation. Also be aware that state laws may be different than the federal law that have been just discussed. If you're in states like California that have a new law every single day, recognize you need to check your local state laws that may supplement some of the things that are going on out there. That's the end of the CYA portion, so I'll let Anita ask the questions.
All right, we have Lois, and she asked, at what point in time do we determine the 50 employee threshold for FMLA? For example, they have 51 employees at the beginning of the week, but had to terminate 2 this week, and now they have 49.
So the time in which you make that calculation is the time at which the leave is being requested. So when the employee comes to you and asks for leave, you then look at, do we have, is the employee eligible? So that's the time you look at it, when the leave is being requested. So if you have 50 or more employees when leave is being requested within that 75-mile radius, then at that point, if that's true, then that would be what determines whether or not the FMLA will apply.
Another question, Kate, if employers can't afford to pay sick leave after April 2nd, should they terminate employees before then?
So that's a good question. If you can't afford to pay sick leave to your employees, would it be better to just go ahead and terminate them before the new law kicks into place? One thing I'll just point out up front is, again, the Paid Sick Leave Act, that, it only applies to those specific circumstances. So you want to, do a quick evaluation of how many of your employees do you think will be requesting sick leave because they are unable to work or telework because of because they themselves have been quarantined, or they're caring for a child or family member who has been quarantined, or they're getting medical diagnosis. Again, if they're able to work from home, then they're not eligible for paid sick leave. But being that as it may, if you've looked at it and realized we're going to be spending a lot of money, presumably we anticipate spending a lot of money, laying off those people ahead of time before the law goes into place, it may be an economic necessity in that case. It may in fact be, and that's just the reality that you'll have to kind of make, everybody out there on a case-by-case basis. When you look at your own workforce, you look at the anticipated cost of paying for sick leave, you have to take that into account on, for each of you based on really the economic realities that pertain specifically to your company.
We have a question from Ken. During a shelter-in-place order to the general population, does that require employers to pay employees since this is related to COVID-19?
So it would implicate either of the two new laws. So the Paid Sick Leave Act, or potentially the Family Medical Leave Act, the Emergency Family Medical Leave Act. Both of those two new laws require paid time off under certain circumstances. There's no other federal law that requires paid time off. So if there is a federal mandate that requires people to stay at home, it's the funny thing is the way those two acts that were passed are written is it says there's if there's an order, a quarantine order. So if there is a quarantine order in place, then the Paid Sick Leave Act would apply to the employee subject to it. However, again, if that employee is capable of working from home, then the Paid Sick Leave Act does not apply to that employee. If the employee can't work from home because of that quarantine order, then he is entitled to paid sick leave once this act goes into place in 2 weeks. Today, he's not entitled to it. Next week, not entitled to it. But in 2 weeks, he would be if he can't come into work and he can't work from home because of a quarantine order. Now, the Emergency Family Medical Leave Expansion Act only applies to an employee who has to stay home to care for a child who is not able to go to school or go to daycare. If that employee in question who's under a quarantine order and stuck at home, if he has a spouse who's also stuck at home who can care for the child, then I would argue he is not required to stay home to care for a child. And so the Family Medical Leave Expansion Act would not apply to him. So we don't have to worry about that. But which again has a 10-week period of paid leave, which is pretty daunting. So you're just dealing with, in that circumstance, the Emergency Paid Sick Leave Act, which is up to at most 2 weeks. And it only applies, again, if there's an order quarantining him or a medical recommendation quarantining him. If one of those two circumstances exist and he can't work from home or she can't work from home, then you would be required to pay that individual once this goes into place in 2 weeks.
Question from Carol. Do employees need to prove that they don't have a spouse or someone to watch their kids?
So again, this would seemingly go to either the Emergency Paid Sick Leave Act, which has one of the eligible qualifications being staying home to care for a child. It would also implicate the Emergency Family Medical Leave Act, which only applies in that situation. It only applies in the circumstance where you have to stay home to care for a child. So I'll lead off with the Family Medical Leave Act, the Emergency Family Medical Leave Act. Any employee requesting leave under that act must give you notice of their need for it, and you can follow up to get information from them to determine whether in fact they actually meet the requirement of that. And so if you are able to determine that they have somebody else in place who can care for that child, then the argument is, and it's a good argument, that they are not entitled to paid leave or any leave whatsoever under the Emergency Family Medical Leave Act, because they are not required to miss work because of a need to care for a child. If there's someone else already in place who can care for the child, then then the argument is, and I believe it's the right argument, or the winning argument, if you will, that they are not qualified to have leave under the act. The same analysis would apply under the Paid Sick Leave Act, which again just gives you 2 weeks of paid sick leave for a number of circumstances, one of which is the need to stay home to care for a child who has a school closure or has a daycare closure due to COVID-19. Again, it only applies, both of those only apply to employees who can't come into the office for that reason and can't work from home for that reason. So you can inquire of the employee to verify or corroborate the circumstance that they are saying exists in order to entitle them to leave under either act. And if you can determine that, they don't actually, they are not needed because there's someone else already at home. If they already have a stay-at-home spouse, for example, in my circumstance, my wife is already at home with our children as it is. So there's no COVID-19 reason that would require me to stay home unless I could show that my wife has gotten sick in such a manner that she's no longer able to take care of our children. Under that circumstance, I think these acts would theoretically apply, because even though there's someone else at home, they're not capable of caring for the child. But if you, again, you can follow up and ask for information, you can ask to for different things to verify what the employee is providing you. And if you determine that they are not actually required to miss work to care for the child, you can use that as a basis to basically deny their request for leave. But keep in mind, if they were to take the next step of filing a lawsuit or filing a complaint with the Department of Labor, it would be a fact issue that you would have to then prove to the Department of Labor or in court.
Question from Wendy. How do we satisfy the posting requirement and document our notifications if we're required to work from home?
That's a really good question. So the posting requirement itself, you're only required to do so in the workplace. So if you're able to have somebody go into the workplace to post it, that would fulfill that requirement, even if nobody's in the workplace to actually see it at the time being. Also, from a practical standpoint, if there's nobody in, if your office is shut down altogether, I don't think you have to run somebody in there while everything's shut down. You can just wait until the office is open back up, people have returned again. At that point, you can post the notice then. So the notice requirement itself, you only have to do in the workplace, whether or not people are there or not. And I wouldn't worry about it until there's actually people present in the workplace to see the notice that you're posting. As far as getting the notice from the employees in question, again, all that can be done electronically. The information they're providing, the forms they're filling out, the health certificates you are requesting from them, those can all be transmitted electronically, or you could do snail mail. You will have to obviously designate somebody within your company as the point of contact. The employee needs to know who it is they're sending that information to and the means by which they're sending it. But as long as you have somebody designated, and I would advise you have a second person designated as well as a backup in case something happens to that first individual. But if you have somebody set up there, the information has been passed on to the employee, you can still require them to give all the notices, all the information that's required under the Leave Act, just as they would if they were there in person handing it to you.
All right, so that is the end of the 5th question. The other 68 questions we will try to figure out a way to get answers to. Ben, that was about $1,500 worth of free legal advice. That was absolutely amazing. Obviously I'm biased, but best employment lawyer in the business right there. Ben, I know you have been working on a package for customers. Can you explain what's in that package to people that are listening?
Sure. So I've been working with some of our construction attorneys. So we have a toolbox talk specifically dealing with COVID-19 that one of our construction attorneys, one of our OSHA attorneys has put together. We also have a job site workplace safety protocol or safety instructions that, again, one of our construction attorneys has put together already. What I contributed to this packet that you're referring to went specifically to these new laws. So these new laws that just went into place Wednesday night, there's literally nothing out there on them yet. So I went through and read the entire, 43-page statute and created basically an outline condensing what this law requires, who it applies to, what employers does it apply to, what employees does it apply to, what it requires, and what you have to do to comply with it. It also states what happens if you don't comply with it. What are the consequences if you don't comply with it? And then goes from there and basically advises companies on different ways in which they can comply with it. And the packet itself also touches on some other areas of law beyond simply the new leave acts, though the primary focus is those brand new leave acts, because we're telling everybody they need to put policies in place, protocols in place to address this, but there's nothing out there to this point that does that, because this law's been around for 36 hours or something. So we understand we're asking you guys to do something that it's difficult to do when there's absolutely no no precedent for this. So we're kind of going ahead and doing it for you to help you put in place those HR policies and the material you need to educate your people as to what's required under these new laws and how to comply with them.
So if you guys are interested in getting that packet or finding out more information, you can contact Ben direct.
You can contact me directly. I'm sure, Trent, you feel those as well, but yeah.
Absolutely. So bbriggs@cotneycl.com or tcotney@cotneycl.com. Hit us up and we'll get it to you. So thank you, Ben. I appreciate your time. I know you got to get back to billing here, so I will let you go. And then for those people that have questions, we'll definitely answer them. I imagine that many of those questions were answered in Ben's very detailed seminar already, but we will reach out to each of you. Just give us some time. So I will go ahead and take over at this point. I'm not going to take a break because I realize that we got a lot to talk about. We're just powering right through it, and I appreciate you guys staying with me. Workplace messaging. This is incredibly important, and it's something that we've struggled with here internally. Obviously, the one thing that you want to stress to your employees is that their safety is the top priority. And I've got my business hat on. It's easy to think about the bottom line, how am I going to keep the lights on, how am I going to make payroll? But to quote one of the other lawyers in this firm, we have to be compassionate. We got to make sure that the safety of our employees is important, that we care about our employees and our family. Obviously, we do here, and I'm sure all of you do as well. So that messaging is incredibly important because you've got to keep morale up. Make sure you discuss the guidelines for safety. HR's role is not only to disseminate information, but to also enforce guidelines, okay? So internally, you need to make sure that your protocols and procedures are being followed. It's one thing, Ben and I can create tremendous documents. They're beautiful, absolutely incredible documents. But at the end of the day, if you don't do anything with them, if you don't enforce them, then they're not worth the paper they're written on. It doesn't matter whether it's OSHA, safety contracts, whatever it is. So we are depending on you guys to carry it out. And again, I can put anything you want to on paper. I can get you legal, 29 ways to Sunday, but at the end of the day, we depend on HR, safety, and management to ensure that whatever we put together is being followed through. Make sure you train and review your employees' policies on sick and leave pay, okay? What I would do is I would get your employees together if you haven't already, and start having meetings. We got to have regular meetings here. This is a fluid situation. John and I were in the back while Ben was talking, and there's been more closures. I can't keep up with it. I mean, it's crazy. We've got attorneys, their only role right now is to follow the law and make sure that we understand what's next. And then obviously OSHA, we're going to talk more about OSHA, but one of the key things is if you got crew that are still active, regardless of whether it's re-roof, new construction, service crews, whatever it might be, you have to make sure that they understand what the guidelines are. Okay, drilling that down to the people on the roof or the people that are out there in the field or the people that are doing AC repairs or whoever it might be, incredibly important. Let's talk about OSHA, okay? OSHA does not have, and I'm referring to federal OSHA, okay? Check with your local state. There's roughly, if I remember correctly, 24 federal OSHAs, 26 state versions. There's some variance in between. Cal OSHA has some specific guidance, but it's very similar to what OSHA is. There is no specific provision that talks about COVID, okay? There is no specific coronavirus guideline. What OSHA has done, and I've provided you with a link here, is this is the guidance that they've put forth, okay? And there's some useful information in there. Doesn't give you all the answers, but at least give you some guidelines. And they kind of punt it on you, the employer, but let me go through it and tell you what it means in English. First thing that they say is the general duty clause. We all know that, you know, if you have the OSHA 10 or the OSHA 30, which we do, that's drilled into you. The employers are required to furnish each worker place of employment free from recognized hazards. So what OSHA has said is that if you are aware of an existing hazard, that you have to follow the general duty clause to ensure that your employees are safe. Okay, that could involve using gloves, eye and face protection, respiratory protection. It could involve a variety of procedures to segregate or eliminate potential threats by removing them from job sites. All of those things are critical. Within that package that Ben referenced, we have a job site protection plan, which specifically identified that. I worked with our OSHA crew, our OSHA practice group, to develop that because we had many contractors asking us for that kind of information. If respirators are required, so there are some of you that are working on high-risk jobs. Most of you, if you click on that link, you'll see a pyramid that OSHA has provided. Most of you are in the low-risk exposure zone, so most contractors are in that. However, you could be in medium or high depending on what type of work you're doing. If you are doing work on a hospital and there's exhaust fans on the roof, I don't know what's coming out of there. Okay, you want to be that you're probably in medium, you may be even in high. Okay, if you are walking into a building that you know is a triage center or emergency care or whatever it might be, you could potentially have an issue there. So think about your respiratory protection. Okay, you might want to do what you can to ensure that your employees have access to that and that they comply with 29 CFR 1910-134. A recent request by the government went out about N95 masks. Okay, we've got a few here. We will probably donate those, but for those of you that have N95 masks, I was asked the other day, what do I do about that? Okay, this is my advice on that. Okay, we have to circle together. Okay, we have got to fly in formation. We have got to figure out a way where we as an industry can come together, help others around us, and help ourselves. Okay, so from my standpoint, if you need N95 masks to perform your work and keep the lights on, then you need to keep them. Okay, if you have extras that you can donate to hospitals and healthcare facilities, then as a human being, you should do it. That's not necessarily legal. That's just my personal opinion. So take it for what it is. Bloodborne pathogens. Okay, this is not a bloodborne disease, but a lot of the framework that is identified in 29 CFR 1910-1030 applies to illness, which is very similar to how COVID is transferred. It creates a very similar framework for a lot of the bacterial infections, MRSA, and some of the other stuff that went around. OSHA has very detailed guidelines on that, and those are useful resources to determine how to deal with the potential spread of this unique virus. So big believer in providing common sense advice. Okay, toolbox talks on COVID. Okay, we've got one. Some of the other associations have one. Drill it in. You need to have them today. Proper hygiene and protection. Okay, you got to figure out a way to provide your crew with the common sense type safety that they need so that they understand the importance of this. This is not a joke. This is not a cold. This is a killer, okay? And if we're shutting down the entire nation and the entire world over this thing, then we need to take it seriously. Last thing that you want is one of your crew to pop, and then you've got to segregate your whole crew, and then you're down, okay? So make sure that you are engaging in proper hygiene and using toolbox talks. Gentleman before asked about getting sign-offs. Yes, you don't want to do safety training in-house. You want to make sure that you can do it remote or engage in social distancing. I never heard of that word until 2 weeks ago, and now it's every other word is social distancing. So I'm going to use it as well. Sterilize common working surfaces. That includes equipment, trucks, and tools. Think about this. How many crew members can you fit in a F-250 crew cab? Okay, I know how many you can fit in there. That's not a very hygienic space. So it is what it is. You can't go out and buy more trucks, right? But what you can do is you can sanitize your cabs every day. You can wipe them down both before the start of work and after the start of work and between work. Do whatever you can. Wipe off the door handles if there is shared tools, shared equipment, anything. I know it sounds ridiculous, but you got to do it. You got to do it because, one, it shows your employees that you care, And 2, you're eliminating liability. Okay, keep in mind that everybody that's on this line, we're all fighting together right now, right? But there are bad guy lawyers out there that are chomping at the bit, waiting for employers to slip. So when this thing is done, they start filing lawsuits and put their kids through college. I don't want to see any of you subject to that. So the more of this stuff that you have in writing, the more that you follow, the better off you're going to be. Job site protection plans. We've had specific customers say that their owners or developers that they're doing work for have requested job site protection plans to protect them in the case their crew or somebody else has coronavirus. So one of the things that these types of projects tend to be manufacturing where food is involved, hospitals, schools. The owners of those projects want a very specific job site protection plan. They want to know exactly what you are going to do to combat it. They want to see it in writing. They want people to sign off on it. They want your subs to sign off on it. We're going to talk about that as well. So think about job site specific protection plans that protect your customer from potential access to someone that is infected. Train superintendents and crew leaders, okay? You have to train, previous talks I've talked about signs of impairment for marijuana, then it was signs of impairment for opioid abuse, now it's signs of illness, okay? Pull sick workers immediately, send them home immediately, okay? You heard Ben talk about it. These are different times. This is not, this is not snowflake PC world anymore. We live in pandemic world. So if you've got it, and I'm talking plain, but that's what I mean. If you've got to pull sick people, you pull them, you send them home. It's not worth infecting everybody else around you. Test for fevers prior to the start of work. Okay, that's something that you can do now, and I encourage you guys to do it, but be safe in doing it. Make sure that whoever is testing recognizes that they're potentially exposed. Job site safety. Okay, this is for when you are on a project, a multi-employer site. Okay, except for emergencies, restrict the job site trailer to your employees only. No one else comes in there. No one else comes out. And strict your access of employees. Okay, all job site meetings are virtual. There are a variety of different things that are out there to deal with this. Teams, Google Hangouts, Company Cam. There's a million different ways that you can communicate. Zoom, you name it, it's there. If anyone on the job site appears ill, they need to be sent home immediately. Okay, I said that before. It doesn't matter if they're a sub, your brother Larry, whoever it might be, send them home. Okay, ensure your workforce arrives with all appropriate PPE and water. Okay, limit loaning of tools and PPE. Okay, don't hand out a bunch of goggles and hard hats and whatnot, because God knows what it's going to come back with. Same with water. Okay, if you've got a communal water jug, think about bottled water. Okay, I love the environment as much as everybody else, but this may not be the time to be as concerned about that. I would justify it based on safety and supply shortages. We've got toilet paper under lock and key here, and I'm being facetious, but you get the idea. Daily reporting, okay? For those of you that are on commercial projects that require daily reporting, switch to virtual only. If you don't have technological capability, you should have a cell phone. Take a photo or use a program to convey the info. Send an email. Remember, daily reporting is useful for you. It's not just reporting about what you're doing on the job. Think about it as self-serving CYA for you, okay? Got on the job site today, it rained for 2 hours. We worked for 3 hours. People on the job site were John, Bubba, and Jimmy, and we engaged in our safety protocols for coronavirus by wearing respirators or whatever it might be. Okay, that stuff is useful because down the road, if there's a claim on insurance, an OSHA claim, bad guy lawyer coming after you, you've got evidence to be able to show that you have done what you need to do. Meetings over 10 people, get rid of them. Okay, use virtual meetings, again, Zoom, Teams, Google Hangouts, you name it. It's pretty easy to find access to that. Maintain the minimum distance. We are here in this conference room and we're all sitting in different tables at the same time. Discontinue in-person safety training, go virtual, a variety of different ways to go about doing that. Most importantly is sanitize and clean the work site, okay? I don't mean, clean the garbage that's on the side of the work site. I mean, look for areas that are commonly touched and clean them. Buckets, handles, any equipment, joysticks, controls, anything that you can think of. You need to have one person on that job site scrubbing stuff down. And I know that sounds dumb, but all it takes is somebody on your crew to pop, and then all of a sudden, everything's shut down. We had a big project here in Tampa 2 plumbers tested positive, that job's down now. Okay, that's hundreds of thousands of dollars stopped dead in the water because 2 people popped positive. Okay, I am going to turn, let me ask if there's any questions on that, and then I will turn to key contract provisions. We're still going to get Roscoe in here. He is getting updates as we speak, and then he's going to talk about all the shutdowns, but I want to continue to talk and give him a little bit more time. Anita, do we have any questions just on that little bit of time I talked?
Yes, question from Wendy. With the worldwide deficiencies of gloves and respirators, do we just make a reasonable effort to procure?
Yeah, so Wendy, great question. Thanks for attending. You got to do what you can. You know, if you don't have gloves, if you can't find gloves, and all you have is a pillowcase, then God bless you. You know, I mean, it is what it is at this point. We got to improvise, adapt, overcome. You know, our industry is strong. We have recovered through worse than this. We will survive, but yeah, you got to make do with whatever you got. You know, it is what it is. Something is better than nothing. You know, we got hospital workers using bandanas. It's crazy, but yeah, do what you can.
Question from
Yep.
Todd. We reduce employees to 1 person per truck. We are asking all other employees to meet on site using their own vehicles and reimbursing. By doing this, are we now liable if they get in an accident on the way to the job site, leaving directly from their house?
So good question, Todd. Yeah, if you have the capability of telling people to use their own trucks and go to a job site, great. But you may have potential liability there. Like, you know, not to mention bad guy lawyers again, but all you have to do is, you know, spend a lot of time watching TV at night. Every once in a while, you know, the contingency lawyers of the world will pop up. And there may be a way, if they are injured on their way to work, to claim that that was a policy that you put in place. As a result, that's a enforced work policy, and therefore that's a something that should potentially be covered. Better yet, is that a workers' comp claim? You know, it depends on state law, so there could be potential exposure there. But what you have to do is balance, you know, the good with the bad. So from the good standpoint, you're eliminating exposure to your other crews. From the bad standpoint, there might be some more liability there. Clearly, you got to compensate. You got to figure out ways to reimburse them if they were used to using, you know, crew trucks, things of that nature. But at the end of the day, it's about getting money on the table. You know, I mean, obviously safety comes first. Your employees always come first. But if you have to come up with creative arrangements, you have to do a cost benefit analysis. And that, in this case, I think it may be worth taking that gamble. I mean, I'll let John speak a little bit more about it. He's got a lot of years experience dealing with these kinds of things, but that's my 2 cents on it.
Question from Hunter. If one person on a crew gets COVID or their spouse gets COVID, then what happens to the rest of the crew? Must they also be quarantined?
So what I recommend is following the CDC guidelines with regard to exposure. And that tells you, you know, what the exposure distances are, how long they've been exposed. It's a lot of those kinds of things, okay? But generally, if you've got one crew member that has been exposed, there's a good chance that all those crew members are gonna have it or be potentially exposed. Safe business practice is to quarantine all of them and tell them don't come back to work till they get a doctor's note, okay? Problem with that is, you know, you got to work. So there's the risk there. But from a legal standpoint, to answer your question, Hunter, like I know, knowing crews like I know crews, unless you've got 4 people that are on opposite sides of a building and aren't communicating with each other, more than likely they're in close contact, and more than likely that is a significant risk to your company. So it probably makes sense to quarantine all of them until they get a doctor's note saying they're okay to come back. You know, that's what I would do. Anything else? All right, guys, this is good stuff right here. We're talking about key contract provisions, okay? Obviously, as a construction lawyer, I live and breathe contracts. I will talk about our subscription plans later, and I want to thank all of our subscribers that are on here. You know that we review your contracts all the time. Let's talk about it. Force majeure and acts of God. First off, what is force majeure? It's fancy legal language, and what it means is acts of God, okay? What does that mean? That means generally in your contract, there should be a provision. It doesn't matter whether it's residential or commercial. Check your contract. If you don't have it in there, you should. It says in the event that there is an earthquake, a fire, war, you know, terrorism, strike, hurricane, then you are excused from further performance, okay? Some acts of God provisions go further than that, and we're going to talk a little bit more. I'm going to show you some examples. Okay, project suspension and delay. That's one of the key things that we've been dealing with. We've had 50 plus calls on projects being suspended, how to navigate those claims, how to submit proper claims. Okay, we are preparing claims around the clock. While Ben was talking, I was sitting there working on a suspension claim for a contractor. Terminations for convenience. Okay, I will tell you all you need to know about terminations for convenience. Material shortages and price acceleration provisions. We will go over that. I will give you examples of it. And finally, I get asked a lot about frustration of purpose or impossibility of performance. Again, fancy legal terms, really they're acts of God type things, and we'll talk about how to deal with that. So let's get into it. Force majeure acts of God, okay? It provides, just like I said, hurricane, war, strike, earthquake. Here's the key thing, okay? Your contracts determine whether or not you've got something that applies to coronavirus, okay? Ben Briggs, Roscoe, myself, and every other attorney in this office, we work magic daily, okay? I can sprinkle a lot of fairy dust on stuff and make it go away, but generally your contract is where we start, okay? So if your force majeure clause has a catch-all in it, or other occurrence beyond the control of contractor that performance is excused, that gives me something to work with right there. See that? Are you guys looking at that? That's it right there. That's the pandemic, okay? That's where I'm trying to get that in there. Now, I have yet to see a force majeure clause that specifically includes pandemics or includes, crazy diseases or zombie viruses or whatever we've got now. But normally the force majeure clause has a catch-all in it. And that's what you need to argue. You need to argue that you can't perform, that it's impossible to perform. We'll talk about impossibility of performance. Okay, keep in mind that you need to read that provision very closely. The first part of that provision normally talks about excusing further performance. What I'm more interested in is getting paid for not being able to perform, okay? It's great that you don't have to perform. I would rather be paid for not having to perform. Does that make sense? Okay, let's look at a very specific pandemic force majeure clause. We drafted this. This is something that you can include in contracts going forward. Basically what it says is any failure or delay by a party and the performance obligations, and we specifically include local, state, or federal state of emergency, coronavirus or similar viruses or illnesses requiring quarantine, yada, yada, yada. Okay, that should cover everything under the sun. And by having that in there, then you have the capability of arguing specifically for this. Again, I don't see provisions out there like this. They don't exist right now. I haven't seen one yet. Most of them are just like the one I previously showed you. But from this point forward, I guarantee that this is how a force majeure clause will look. Let's talk about project suspensions. Starting 3 weeks ago, we started getting phone calls about projects getting suspended or delayed. First, Roscoe will talk about the shutdowns, Boston and the Bay Area. When I was doing this PowerPoint, getting it together, those were the two. Now it's Pennsylvania, New York will be soon, LA, all of California. It's crazy, okay? Miami. Public stopped all construction on its job sites, at least for, remodels? Remodels new is still going on right now, but that's a major box store, and there's others that have followed suit. So what do you need to do if your project is suspended? Well, let me tell you. First thing you need to do is look in your contract to see if there is a suspension claim, okay? The ability to make a claim for suspension. You want to see if there's a specific provision that talks about the customer's ability to suspend a project, regardless of whether you're a sub dealing with your prime or you are a prime dealing with the owner. That suspension provision will tell you exactly what you can do and what you can't do. A classic example is in AIA A201 2017 section 8.3. Okay, you can download that. You can download a draft copy. It's copywritten, but you can download a draft. And it contains a detailed provision on requesting time, and in some cases you can actually request cost for delay. Here is where we have had an issue. Is it an act of God or is it a delay? Okay. So oftentimes what we do when we're submitting stuff is we submit it under section 8.3 if it's an AIA document dealing with delay. But sometimes it may fall within a different provision, and we'll talk about suspension provisions and things of that nature. Watch out for no damages for delay clauses. So when you're looking for delay in your contract, normally if it is given a contract given to you, it will say you have the ability to seek time for additional delay, but not cost. Okay, that's known as a no damages for delay clause. There are ways around that. Okay, impossibility of performance may get you around that. Active owner interference may get you around that. If the job site is closed, that may get you around it. But the arguments that we're having to deal with is we say force majeure act of God. They say, no, this is just a delay. You need to make a delay claim. Okay, that's been the arguments there. So you want to make sure the key thing is, and for those of you that have heard me speak in the past, the party with the best paper wins the day. You must be proactive on your documentation. Okay, you must make sure that you are crossing your T's and dotting your I's, and every single suspension claim should be in yesterday. Okay, get those claims in. The party with the best paper wins the day. If you are at the front of the line, there's a better chance of you getting paid if you wait till 2 weeks from now when everybody's shelter in place and we're boarding up houses. Okay, so what I suggest you do is get the suspension claims, get the delay claims out now. If you read your contracts, most of your contracts require very specific backup documentation that you have to submit in order to make sure that you have a valid claim. Don't be a bonehead and not submit that stuff. That's why we're preparing claims on our end, okay? Be an advocate. I was speaking to a contractor, this was a while ago, about 5-6 years ago. He said he hired somebody solely to write RFIs because he was a professional RFI writer, because depending on how you write that RFI, you might get paid for an extra or not. Okay, you need to have the same advocacy hat on. You need to put your best foot forward, follow the contract language, follow everything that is required to be submitted. If you have to submit backup cost, backup, labor cost, material cost, whatever it might be, get that in there and submit it. Let's talk about terminations for convenience. Okay, terminations for convenience. I'm a little bit of a history nerd, so I'll tell you terminations for convenience came up in World War II. The reason they came up is because the government was signing contracts left and right, and the government needed a way to get out of these contracts quickly. So they developed terminations for convenience. What that meant was that they could terminate the contracts at any time for any reason, with or without cause. Many commercial contracts contain terminations for convenience. The key thing that you want to look for is make sure that you have terminations for convenience downstream, okay? Because if you get terminated for convenience and you don't have that provision in your subcontract, you could still be liable to your sub, okay? Terminations for convenience allow the customer to terminate once they provide notice and they abide by the provisions that are within that contract. I mentioned here section 14.4 of A201 gives you a classic example, okay? Normally, and it depends on the wording of the contract, the terminated party is entitled to lost profit and work on the work performed, is entitled to the profit and overhead on the work performed, but not lost profit. Okay, so let's say you did $25,000 worth of work, and in that $25,000, there's $5,000 in overhead and profit, then you're entitled to submit a claim for $25,000. Okay, you can't submit a claim for the other 15 that you might have gotten had you finished the job. So it cuts off what you can get, okay? That is not a good deal. Being terminated for convenience is not good, okay? I was up at NRCA speaking last week. I was talking to a contractor. The contractor said they got terminated for convenience, and he now has 12 crew members that are without a job, and it's difficult to find work immediately to replace them. Now, construction industry was booming 3 weeks ago, and it's still pretty viable now, but the government's making it impossible for us to continue to do work. The virus is making it impossible. So finding work for those people to do is very difficult. That's why these provisions are troublesome, because if they happen, then there's not a lot you can do contractually other than seek your cost and reasonable profit and overhead that are on those amounts, okay? Before I get to price acceleration, let me answer a question that I'm sure you guys are asking now, okay? And here's the question. Trent, we love all these contract provisions that you're giving me, thank you, but I don't have anything like that in my contract. All I have is a handshake or proposal. Shame on me. I will contact you after this to draft a very nice contract. Okay, the answer to that question is, what do you do? Okay, here's the answer. What you do is submit a claim for equitable adjustment, okay? What you can ask for is you need to write a letter or write a claim that says, look, I can't perform your work anymore. I'm going to have increased demobilization, remobilization cost. I'm going to have increased delay claims. I'll absorb some of this, but I need you to absorb the rest of it if you want me to continue work on your project after this is done. Okay. Is it a guarantee? No, it's not. But like I said, the squeaky wheel gets the grease. So it doesn't matter if it's in your contract or not. Submit a claim. Submit a claim because you're going to have additional cost. Okay. Work with your customers. You know, obviously, you know the customer better than I do. So the idea is work with them. You know, try to figure out a way where both of you guys can continue to do work, continue to get paid. That's the goal. Okay. Back to price acceleration. There have been material shortages that we have started hearing, galvanized nails in certain areas. We've had some reports of specialized equipment being unavailable because of it being stuck in the port due to coronavirus. We've had anything that is sourced from China, we've had problems. We've had problems from material manufacturers out of Seattle. We have seen inability to obtain goods. Now, I will tell you that I haven't seen a sharp increase in prices yet. Okay, I have seen a little bit, but really it's availability. Okay, so it's delaying projects. If there is a big spike in materials, you want a price acceleration provision in your contract. And what that says is that in the event that any material line item increases by more than X percent, I put 5% in here, then you're entitled to an automatic adjustment of the contract. Okay, you don't need a change order. You don't need the architect, the owner, the architect's brother to sign off on it. You just automatically get a change. Okay, what you do is you submit the cost. The owner sees what the costs are. The change is made based on that. Okay, this provision came about primarily because of hurricanes. Okay, anybody that works here in Florida, there's some people that we got from Texas. Good luck finding plywood, you know, after a hurricane. Very difficult. So you stock up on that stuff, and the price of that stuff goes through the roof. So it's important to understand that you add these kind of provisions in there to protect yourself. The other thing is if you have this in here, keep in mind that your contract serves two purposes. One is it's obviously designed to protect you, okay, and to help you prosecute claims. But the second is to educate your owner. Okay, there's a lot of provisions that I put in a contract that don't necessarily that are sort of like duh provisions. Example is a pre-existing conditions provision. I, the contractor, am not liable for any pre-existing conditions on this job site, you know, including mold, you know, termites, algae, dry rot, et cetera, et cetera. Okay, duh, of course you're not liable for pre-existing conditions, but having something like that in there allows you to communicate with your customer and say, remember when we walked the job site and we took photos and videos of the job site and we saw that there were some damaged ceiling tiles, or we saw that there was cracked stucco, okay? Remember this provision, this is why we're not gonna give you a set off for this, okay? It allows you to start having those negotiations. Managing customer expectations is the most important thing to do during this time. It will make or break you. So if you have honest communications with your customers, if you stay out in front of them, if you communicate with them, if you let them know that you're available, that you care, then that is going to make all the difference. I guarantee you in my inbox now, I have 25 emails from my vendors begging me to still pay them. Okay, that's not really what the emails say, but that's the gist behind it. Let's talk about frustration of purpose or impossibility of performance. I mentioned earlier, the question that I'm sure many of you have is, all these provisions are great, but I don't have any of them in my contract. What do I do? Okay, you still have the capability of arguing that because of shelter in place rules, because you are no longer able to work on job sites, because you can no longer source materials, because, you know, some of your crew may be ill, you can no longer perform it. Therefore, you need to adjust the time, you need to terminate the contract, you need to figure out how to get paid more. All of these things give you a potential argument, okay? Rarely do I see a specific frustration of purpose or impossibility of performance provision solely in a contract. It's usually combined with other provisions, okay? The acts of God provision is basically a frustration of purpose provision. But here is an example of one that is in contracts. Neither party to this agreement shall be deemed to be in violation of this agreement if it is prevented from performing any of its obligations hereunder for any reason beyond its control. That is very simple, okay? And usually that's included within acts of God or termination for convenience provisions or suspension for convenience provisions. So keep that in mind. That does give you a potential argument to make in the event that you can no longer perform work. And everybody's in this together, okay? We're all experiencing the the same issues right now. Summary of part one, and then we're going to get Roscoe in here. Roscoe is going to talk to you about what the current state of affairs is. First thing is don't panic. Okay, we are here. We are here. We're giving you information. We're fighting for you. We'll guide you through this. We're all in this together. Keep fighting. We're going to get through this. Okay, construction is strong. We will get through it. Plan and prepare. Don't wait for shelter-in-place rules to happen in your state of Kansas, or your state of Indiana, or your state of Pennsylvania's already got it. Whatever state you're in, prepare for it now. What happens if you have shelter in place enacted on Monday? Are you prepared? Are you prepared? Okay, if you're not, then as soon as you get off of this, start working on it. Update your policies and your contracts. Okay, safety manuals, HR manuals, contracts, both upstream and downstream. You have to absolutely look at adding these kinds of provisions in there, especially if you're executing new contracts. Key thing is be ready. Okay, I'd love to say I came up with this quote myself, but a setback is a setup for a comeback. We will come back. Now I've got Roscoe on his way. He will be coming here shortly, and what we're going to do is update you on all of the recent shutdowns and changes. As I mentioned to you before, Roscoe is licensed in Georgia and Florida. He is general counsel for minority contractors, CGC, and a general contractor before being a lawyer, and he is about as real as you get. So I will turn it over to Roscoe, and then I will answer any questions that you guys had after Roscoe presents. So Roscoe, take it away.
Thank you, Trent. All right. So we know there's been a number of states that have implemented bans on construction-related activities, obviously to curb the spread of the virus. I will go through the ones that I'm aware of right now. There are about 3 states or 2 states and multiple cities. First, let's start with California. Obviously, California is in a state of emergency. There's been 1,000 tested positive for the virus. 19 have died. The governor has come out and said that 25.5 million people will be infected over the next 8-week period. And so Governor Newsom has issued a statewide restrictive order restricting all residents or mandating that all residents stay at home except as needed to maintain the continuity of operation of the federal critical infrastructure sectors, critical government services, schools, childcare, and construction, including housing construction. So in California, the construction activities can continue. This order is effective March 19th, which was yesterday, and it's in place indefinitely. It exempts workers in the 16 critical infrastructure sectors, which are provided by the Presidential Policy Directive, that's PPD 21, which can be found on the U.S. Department of Homeland Security's website. Those 16 critical infrastructure sectors are chemical, commercial facilities, communications, critical manufacturing, such as primary metals, machinery, electrical equipment, appliances, transportation, dams, defense and industrial bases, emergency services, food and agriculture, transportation systems, and there's a full list of those on the website. Commercial facilities are really, your entertainment and gaming, lodging, amusement parks, stadiums, things of that nature, retail stores, shopping malls. So construction activities can continue in California as of right now. It's just citizens are not allowed to leave their houses to do that, do those activities. So the fines in California, guilty of a misdemeanor if you violate, imprisonment up to 90 days or both, and you can be found guilty of a separate offense for each day that the violation continues. Right now, California isn't as strict as some of the other locales, such as Pennsylvania. Pennsylvania implemented a state of emergency and then also put in an order, executive order yesterday that ordered the statewide closure of all non-life sustaining businesses until further notice. And all means everything construction related, effective March 19th, and it's in effect until further notice. And what that executive order does is prohibits the operation of any business that is not life sustaining, regardless of whether the business is open to the public. Now, it will not apply to virtual or telework operations, your operations from home. But if social distancing measures are followed at your house, life-sustaining businesses may remain open for now, but must follow mitigation measures defined by the CDC. The enforcement of the executive order begins on March 21st. And the governor has come out and said, the failure to comply could result in the forfeiture of the right to receive disaster relief. Forfeiture of state loans or grant funding could be terminated. Licenses could be revoked, fines or imprisonment. Now, he says he's going to enforce, the order says he's going to enforce those things, but he's recently backed off or appears to be backing off of those statements and said he's not going to send police or National Guard to enforce the orders for whatever, take that for whatever it's worth. But in reality, the executive order is in place, so they could be enforced. Non-life sustaining businesses are, the important ones. There's a number of non-life sustaining businesses that are identified on the state's website. One of them is construction. It's considered a non-life sustaining business. Tobacco, computers, manufacturing, electrical equipment and appliances, furniture, car dealers, specialty food stores, florists, vending machines, those types of activity, real estate, even professional services, including legal, accounting, architecture, computer systems and design. Those are all considered non-essential or life-sustaining business operations. So you are precluded from doing those activities in Pennsylvania. Now, life-sustaining businesses may remain open. Again, there's a list that you should go onto the state's website and take a look at that list. But a few of the more relevant categories are cement manufacturing, manufacturing of electrical components and navigational instruments, beer, wine, and liquor stores. They definitely need that to sustain life, and all electric and water service or sewer utilities. Those are a few of the relevant ones. But again, go on the website, take a look at those so you know what you can and cannot do. Earlier this week, the city of Boston also announced a moratorium. It went into effect on Wednesday, but it was announced on Monday, which also bans all non-essential construction activity within the city, and it applies only to projects permitted within the city. It takes effect March 17th. The city is suspending all regular activity at construction sites, and it's going to be done indefinitely. The governor or the mayor has said likely 14 days, but that the moratorium is open-ended and indefinite, so it could go longer. And the way it reads is through March 23rd, employers should maintain crews on site necessary to keep the job site safe and to secure it. That means the language they've used online is to keep materials away or keep materials from blowing away and to prevent trespassing. So through March 23rd, Employers should maintain crews on site necessary to keep the job site safe and secure materials from blowing away. After March 23rd, you are allowed to keep a skeleton crew on site for the remainder of the suspension to ensure safety. Only essential emergency construction work will be permitted. And there's guidelines also that you can find on the city's website that says, essential emergency construction work is considered, things like emergency utility road or building work, such as gas leaks, water leaks, or sinkholes, new utility construction to occupied buildings, mandated building or utility work at public health facilities, your essentials. And it only applies to projects permitted in the city of Boston. No new projects obviously are able to be constructed. The city will review exceptions to the moratorium on a case-by-case basis for what it's worth. But again, violations, you would be subject to municipal fines or complaints, and a number of other things that you could imagine would come along with violating a municipal ordinance or law. And then after Boston implemented their moratorium, the city of Cambridge also issued a moratorium that is very similar to Boston's, and it also bans all non-essential construction work on project effective March 19th until further notice. A lot of the scopes that they identify as essential emergency construction work are similar to the ones that I referenced in regards to Boston's. But on March 21st, or by the close of business on March 21st, all construction activities must cease, and sites may be accessed to make sure that they're safe and secure. But by close of business March 26th, you're obligated to have all safety measures in place, and the job must be safe and secure. And then after March 26th, there only essential emergency construction work can take place within the city. And again, that's work essential for maintaining life safety systems, your emergency work necessary to make the building safe and sanitary, such as repair of a failed heating or electrical plumbing system. Work to maintain all, make measure, or work to keep the project safe, or the job site safe. Those are the activities which they consider essential in the city of Cambridge. If you'd like copies of these orders, please reach out to us and we can get you copies of the orders so that you can read them yourselves and familiarize yourselves with them. But we suspect that other states and cities are going to follow suit, and some, are probably getting together today to do the same. I was reading an article this morning. Looks like New York is getting ready to do something similar. And so you want to stay up to date, and we expect this to happen, across the country. So if you have any questions, please reach back out to us. We'd be happy to walk you through it or go through it in more detail on a case-by-case basis, because I know many of you are in a wide variety of scopes on the project. So feel free to reach out to us.
Okay, thank you, Roscoe. So we have one question back from the previous contract section. Anita, will you read that one for us?
Does AIA 8.2.1 standard language covered COVID-19?
So I'm going off of memory here, but AIA 201, A201 2017 8.2.1 deals with progress and completion. I think it just discusses time limits. 8.3 is delays, and it's somewhere in there where it talks about how you can submit delays. As far as a specific force majeure or acts of God provision, oftentimes I see that included in 101s or 111s or 401s. But rarely do I see anything that specifically calls out pandemic. Usually there's a catch-all similar to the first force majeure provision that I identified. So now we're getting to, if you thought all that was good, now we're getting to the really good part. Okay, so this is John Kenney who's going to talk here shortly. But before we get to John, I want to thank every single subscriber again. Okay, we greatly appreciate you. If you are a subscriber, you are on here for free. You get access to us 24 hours a day. Okay, if you need us, we are there during the good times and the bad times. Okay, how does our subscription plans work? Well, it's very easy. You sign up, you get unlimited document review, unlimited phone calls, exclusive discounts, and you get an attorney on demand when you need them. You don't have to worry about what the bill is going to look like. You know exactly what's included and what's not included. The plans, here's an idea what our plans look like. Basically, it's a set monthly cost. Great example is if you go to the bronze plan, you get an attorney on demand. You get unlimited phone calls. Think about that. You can call your lawyer anytime you want. And it's not just me. You can call anybody in this office. And here's the key. Anybody in your office can call us at any time for any reason. So if your HR person has a question, your project manager, the crew leader, the janitor, whoever it is can call us and we will answer their questions unlimited under this plan. Unlimited demand letters. You want pay up or die letters? We do that for free. Unlimited contract review. Okay, it takes me a couple hours to review one contract. If you get 3 or 4 contracts in a month, you have made your money and then some. The average savings for clients that are on our subscription plans are 53%. So now more than ever, if you want an attorney on demand, if you want VIP treatment, if you want to be the head of the pack, when the calls come in, VIPs and subscribers, the subscribers we have, those are the ones that go to the top of the heap. So thank you to all our subscribers. We greatly, greatly appreciate you. We will continue to be by your side and show you value add. There was a question, right?
Yes, there is a question for Roscoe. What about service repair work to life supporting businesses in Pennsylvania?
You have that one, John, or do you want to? Okay, Roscoe, go ahead.
All right, so what about service?
Service repair work in Pennsylvania, can they still do that?
It depends on whether or not, and the order does not say, but if it's on one of those 16 critical infrastructure sectors, if it's a hospital, the governor didn't say, he specifically said non-life sustaining businesses or construction. It does not go into detail as to what that really means. But if you're going and performing service work on a hospital, I think you fall within, the intent of the law and that you're performing a service that is critical to the infrastructure. But, you may want to reach out to your local officials or the governor's office and find out. Just my gut tells me that would be okay.
All right, thank you, Roscoe. I will let you go. And again, if you guys have any questions for Roscoe, rgreen@cotneycl.com. I think the world of Roscoe. We are in this together, and I couldn't do it without him. So thank you, Roscoe. Really appreciate it. Now, without further ado, the roofing legend, John Kenney, a good friend of mine. He's got 45 years experience. John, thank God, is not a lawyer. He will be able to tell you the real world issues that you need to do to scale your business properly down so that you can survive these times. John, my brother, I turn it over to you.
Okay, thank you very much, Trent. Good afternoon, everybody. A lot of information has been flowing all morning. It's super informative, even on my end, sitting and listening to all the changes that are happening as fast as we can possibly digest it all. But we got a couple issues to deal with. We got the COVID created environment and economic conditions, which are something none of us really anticipated coming into this year. And then we got to get through that, which we will, because we're a strong industry and a strong nation. Eventually all this will pass. And then we got to position ourselves to hit the road running for when the comeback comes. So one of the most important things right now, of course, is cash flow. And everybody's going to be protecting their cash flow, including the people that are going to be paying you. So you definitely do not want to lose a step in collecting your cash. If it is collectible, you need to go get it as soon as possible. It's going to be a big issue coming down the road No one really knows how long this is going to last. The information changes almost hourly of who's closing, what's going on, and what we're doing. So work on your cash flow. And then when you get that, as much as you can get in, and hopefully you have a good reserve with the economy being well, you need to do proper budgeting and forecasting. And we're even doing that here. You need to look ahead and see what bills you absolutely have to pay to keep your doors open and keep your employees going that you need to keep going.
Pay your lawyers.
Pay your lawyers. But the most important thing is when you do these, you got to put them into lists. You need to look at it by essential payments, next essential in line, and then there's going to be some payments, unfortunately, that are not essential, and only you can decide that for your own business. A lot of people have talked about shutting down the sales and marketing efforts of the companies. I've heard that on some webinars prior. That's a call you need to make yourself. Some businesses, it's essential to keep their names out there, but with social media, it is even easier today to get your name and keep yourself on top of the market. But most importantly, keep it going out there that people get the information from you. They know you're okay. They know you're there when you need them. I'm jumping ahead a little bit. It's not really with cash flow, but since we got on it. KPIs analysis at all your locations, especially if you're a multiple location company, you want to make sure that you know what your key performance indicators are. Hopefully you've done that. If you haven't, there's never a better time to start working backwards to do that. Routine monthly reporting and updated profit and loss statements and balance sheets are the norm, but right now it's probably a good idea to look at them on a weekly basis to make sure you don't have any outliers that are coming at you. Year-end forecasting for cash flow. So that's easy, something most companies can do very easily. Right now it's going to be more difficult. You absolutely want to make an 8 to 12 week projection on your cash flow, and you need to look at possibly cash flows not going to be as normal. So that, again, that goes back to getting prepared. Access to credit, short-term credit, credit lines, angel investors, and venture capitalists. Well, probably a lot of those were great prior to this going in, but right now your best bet is to work your terms with your vendors. They're your partners. So the ones that you've been working with the most, don't hide from them. Feel free, and you need to reach out to them to let them know that you're planning on making it through this and what possibly they can do to help you during the cash flow shortage. They also are going to have the same issues that you're having. So I'm hopeful that everybody works together on that. Institute SOPs for all aspects of your operations. Now, if you haven't done it, you're going to have some downtime, unfortunately. So now's the best time to do it. You need to start doing your crisis management now. We put out a roof report last night that deals with the crisis management, and it also deals with securing your job sites and documentation. If you haven't read it, I recommend you do read it. It's got a lot of great information in there. And again, as Trent said, we are working night and day to try to get information out to you to help you through this crisis and well and beyond. But you want to take a look at everything, your AR, your AP, your estimating, your sales, your field operations, your legal, your HR and safety. Everything now should be looked at and make it run as efficient as possible as you can. And I've always been an advocate, if you've known me, which a lot of I know you out there on the phone know me, I've been an advocate of standard operating procedures throughout my career. Now you do have some downtime to get through this, so now's the best time to work on it. Utilize software to assist you in tracking. There's all kinds of stuff out there, especially now with the social keep away and all the other good things that are going on out there to keep you from getting sick. Now's the best time to do it. We'll talk a little bit more about software in a minute. Focus on issues with employment, employee manual updates, including ongoing training. I'm not going to spend a lot of time on that. You've heard on the legal side throughout, but now's a good time to work on virtual training. If you have online training training devices, make them available to your employees and make sure that they're doing it. If not, there's plenty of resources out there that can help you through it. Again, everyone's going to have a lot of downtime, and now's not the time to sit home and not do anything at all. It's a great time to keep people engaged. Ensure that contracts are reviewed by ownership, not just your estimating and sales. You definitely heard about the clauses from Trent and the others that you need to watch out for. You are the only one that can protect yourself, so you need to make sure you're reading these thoroughly and not getting yourselves into any situations that you should not be into. Great time to update your safety manuals to reflect current conditions. Most of them out there don't have to deal with these pandemics, but now unfortunately we do, and it's probably going to be something we're going to deal with from here on out, especially with the way the media and everybody else is broadcasting it. It's not going to go away.
John, just to let everybody know, Illinois just announced that shelter in place will go into effect, I believe, tomorrow. Thanks for Jessica at CRCA for telling us that. We'll continue to get information out. It's constantly changing, so.
Again, on this slide, basically just an example of what you can do with an SOP. Regardless of how you put it, you want to have a purpose, a scope, prerequisites, reference back to what your company procedures are, and have definitions and responsibilities, and then write your procedure. One thing that I've recommended to everyone that I've ever worked with and people that call me up, your standard operating procedures should not look like a text manual of the old Sweets catalog or anything near that. It needs to be a simple, understandable document, and eventually be able to put it onto virtual so people can gain access to it, whether they're on a job site, whether they're working from home or anywhere else. And it should walk them through their job duties very simply and precisely. The less complicated, the better a standard operating procedure is. Evaluate your team. Now, there's never been a better time to evaluate your team. Define the roles of your HR, your COO, your controllers, your production, your service, and all your managers. Now's the time to go and make your list. Who is doing what can they do better, who you can cross-train. Now's the time where you may have somebody go out sick or whatever happens in the industry at this point. Who can cover for who if something happens? Manage your managers. Make sure that you are putting them with proper direction on what to do each day. Get your message out there. Most importantly, lead your team. Your team and everyone else, including your customers, need to know that you are in control. As much control as you possibly can be in with a changing environment daily, but they're looking to you for leadership. Now is the time to give that leadership. Supply chain logistics. Another thing that we covered in the roof report as part of this in your job sites. When we get shut down, as you're seeing in the States, we don't know if it's 14 days, 6 weeks, 8 weeks. We have no idea when they're going to lift the ban. So you do not want to overstock your jobs. You work with your suppliers, as was touched earlier, see if they can have some stuff on hand for you. You can pre-buy, but absolutely now is not the time to overstock any project. Because if the shutdown happens, there's something that's not going to stop regardless, and that's going to be weather. There will be severe weather. There's still tornado seasons. It's still rough weather with hail, rain, winds, and everything else. So you're going to lose a lot of material if it's not properly stored and maintained. So with all the problems we have now, you definitely don't want to run into that as you go along. So reach out to your top vendors and manufacturer partners. Talk to them about what their shutdowns are looking like, what the availability is going to be. Because no matter what is going to happen is we are going to get through this, and we are absolutely going to have an industry boom again. It happens after every cycle. It's just at this point, we don't know exactly when that's going to be. But position yourself for the recovery, because there will be a recovery. And you want to make sure you are leading the industry. Negotiate favorable terms with your suppliers. I guarantee you they're going to be willing to work with you the same as you're going to work with your customers. Also work with your customers on terms. If they can't pay you in full now, work out a payment plan with them so at least you know the money's going to flow over a reasonable 30, 60, 90-day period. Development and competitive edge. As we just said before, we are going to come out of this and the economy can rebound quickly. One thing that I've been reading on it, I've been trying to stay up with all the economists, as difficult as that may be with all the news changing, but even with the market fluctuations and everything else, there was a tremendous amount of pent-up construction and money in the market systems out there. It is going to come back. It is going to be there and it's going to come back strong. So get prepared for it. Get through this, do what you can to be prepared, but take this downtime to get yourself to be the industry leaders when it comes out of it. Get your company prepared now. Use virtual training to cross-train vital positions. Set time aside to video train your workforce. If you don't have it, start working on it. Use social media to release valuable information about your company. You want people to know you're okay. You want people to know you're working on everything that you possibly can and you're there for them. Post some positive posts now and then. One of the things that now Trent and I like to do is we're big history buffs, and both of us have a huge collection of memorabilia from the roofing industry. I enjoy doing that more than I do putting the other information out there, because it's something to entertain myself and hopefully the people that see it. So don't be afraid to do that. We can't sit in behind the screen all day and watch all the bad news. Take advantage of technology to better position yourself for now and the future. We use and develop our clients' business suites on smart sheets. One of the things you'll get at the end of this is a video presentation that I did a webinar for smart sheets on construction. I think if you haven't seen it, it's a great video to watch to learn what possibly can be done and all the benefits to getting yourself. Not everybody is fully onto technology, but I think one thing the pandemic is going to push, is going to really push the technology even further and further ahead, so that we're going to be pushed to get into it earlier and earlier. So be a leader on it. And if you have any questions whatsoever on any of the stuff that I covered, please feel free to reach out to me. Take advantage of the technology to better position yourself now and in the future. Remember your core values. You all have core values of why you started your company, how you deal with your employees, and how you deal with your customers. Now's the time not to go off track. Live by your core values. Do a SWOT analysis. This is a very important time to look for your threats and your opportunities. More so, one reality we all have to face is we're going to have to probably, as I've gotten numerous amount of messages and texts in the back room while I was sitting through here, of people that are furloughing and laying off employees. And I mean, I actually read Fields Entertainment, which is right here in Bradenton. They went in this morning and 90% of the entertainment force got their furlough letter this morning. So it is a reality. A lot of industries got hit hard. So you need to keep your key people and you put the list around you so that when the recovery comes, you're ready to do it. So now's the time to really look tight at every one of your personnel and work with them and train them and do what you can to keep everything going. Competitor reporting, integration of old guard with new employees. Right now, you're probably not going to hire too many new employees, but one thing for sure is you will in the future. So get yourself prepared how you're going to integrate your workforce of the future. One of the things that Trent and I did kick around last night is with people getting laid off in other industries and the shortage that's in construction, now's a great time to think about workforce training, because it's an opportunity to bring people into our industry as soon as this thing kicks around again. So please take advantage of that.
So Anita just stepped out. She's going to come back in here, and I just want to reiterate what John said. You know, it doesn't matter what ends up happening. I mean, if you know, with Illinois going shelter in place now, it's just a matter of time where every single state's going to do that. Okay, you guys need to face the reality. That's going to be the case. So get it while you can. We are working on a plan to stay up regardless of what's going on. You know, John and I will be the last to go down with the ship. So you can always get a hold of us. We will make sure that we're doing whatever we can to stay in touch, even if we've got to work remote. We are completely cloud-based, so we shouldn't miss a beat when it comes to that. I've been working 20 hours a day, as has John, for the last couple of weeks, and I will continue to do so to make sure that everybody has got the protections that they need. One of the questions before was asked about AIA. Eric, I think you asked it. A141 13.2 does have an act of God provision in there that talks about national emergencies. So that is a provision that can be looked at for an example of that. Don't see necessarily that same thing in 201, but 141 might have it. You can get a draft version online at AIA. Do we have any other questions? Okay. Well, I thank you guys. We are going to figure out some way to post this and get it out to you. That was one of the questions that I did see. Again, if you have any questions about subscriptions, about the package that Ben talked about, or anything that John talked about, feel free to reach out to any of us. John's email is jkenney, that's Kenney @cotneycl.com. Mine is tcotney@cotneycl.com. And we are happy to answer any questions that you got. Stay positive. We will get through this and keep on fighting. Thank you very much.